Only
Yes.
one review application. Review application of your lordship's order.
What application?
Review application.
Review.
My lord, I'm mentioning for inclusion. This is a pension matter, my lord. There was direction
For
to
hearing,
for hearing.
please wait for some time because I have accepted some of these slips. Let me dispose of few matters. Thereafter, I will consider.
My lord, kindly, if you could, it's 2018 matter, my lord.
I appreciate.
But I had a
Mr. Saraf.
similar prayer. If the matter appears at least in the list, as the
Mr.
last
Banerjee, I have
matter.
accepted some of the slips. Let me do because
The
you
difficulty
know
is
this
the
is not a
client
regular.
may kill us. The client may kill us, Milord.
But
That's
I
the difficulty.
appreciate that. But let me dispose of few matters. Thereafter, I will again.
But I just indicate one more thing, Milord. I'm not insisting upon enlistment of the matter. Milord, he was the assistant registered of NUJS. Milord, I believe Milord has no difficulty, Milord, in taking up that matter. Milord, he has been terminated, Milord, on account of Milord sexual harassment at workplace. Affidavits exchanged. Otherwise, I will not trouble your lordship, Milord, further. That's why, Milord, I just indicated this.
You can take a chance before another bench. If not, then let me see.
Then Milord, may it appear as to be mentioned and released.
Not
Milord,
now.
wait.
Yes.
Two matters are related to
Hearing.
hearing.
Hearing. Please wait for some time.
Legal aid matters, my lord. They are senior citizen aged about 80 plus.
Let me dispose of unnecessarily listing matters will not help. Let me dispose of few matters. Thereafter, I will again.
My lord, from the legal aid, they keep on asking for the.
Madam, if I accept all the slips, if I list all the matters, it will not help.
Well, I am
Unnecessarily list will be. No, just call the list.
But may I be permitted to mention, my lord,
Number
number
157
and 158 of your lordship's
Lordship,
today's
I'm
list for
appealing.
upgradation. Urgency is that, my lord.
Hearing. No upgradation. If you want, I can release that.
No, my lord. Certainly not.
One.
May it please your lordship, I am appearing for the petitions. Item number 1.
Two, Lord. Two and
Appearing in case of the petition is in item number 1. my lord.
for the petitioner, my lord. My lord, he's on his legs before justice. My lord, Ananda Bandha. I'm praying for
You are here.
my lord. Pass over, my lord. My lord, he will be there. He will do the matter, my lord. He's ready with the matter, my lord. I'll praying for short pass over. 2
May
and
it
3.
please your lordship, I beg to appear for the respondents in item number 1, Coal India.
Item number 1 at 110, it will be taken up.
Grateful.
All right, pass over.
My lord, deeply obsessed. 3 and 3. 2 and 3, my lord.
2 and 3, pass over next.
4.
Log, Dada.
Log, yo. Very
Log.
And I am for the opposite party number 14.
Where is the petitioner?
Mr. Gopal Ghosh with Mr. Rajkrishna Mondal.
Yes, Mr. Rai, what is this matter?
My lord, it is with regard to the, my lord, assessment of the stamp duty in respect of the property. My lord, the trial judge directed to assess the property by the
Instrument was impounded.
Now, my lord, this
Sent to the
order of
collector.
my lord.
Sent to the collector.
Yes. Now, my lord, the order passed by the collector that was challenged up to the Honorable Apex Court that has been affirmed. Now, my lord, an application has been filed to, my lord, revive the my lord, assessment. Now, my lord, kindly come to, my lord, page 91. My lord, before that, my lord, kindly come to the order passed by this honorable court once. Then, my lord, it will be easier.
Mr. Rai, can you ask your junior or clerk to inform Mr. Ghosh? Yes.
Now, my lord, kindly come to, my lord, page 77 first. The order assailed before this honorable court. Page 77.
Yes.
Now, my lord, may I read for you, lordship, my lord?
Yes.
The present dispute concerns and orders of the trial court accepting the assessment made by the collector in respect of a particular plot of land, which was the subject matter of an agreement sought to be relied on by the plaintiff petitioner for the purpose of proceeding with the suit for specific performance of the said agreement. Learned counsels for the petitioner argues that the collector gave no opportunity to the petitioner to present the petitioner's version of the appropriate valuation of the property and unilaterally assessed such stamp duty. The court as such acted without jurisdiction in accepting such assessment mechanically without granting any opportunity to the plaintiff petitioner to controvert such assessment. It is further contended by the learned counsel for the petitioner that since the prayer for specific performance in the suit is restricted to Schedule D of the plaint and the plaintiff petitioner has already deposited adequate stamp duty in respect of the sale deeds executed in connection with the other portions of the property encompassed by the agreement, the trial court also acted without jurisdiction in directing the plaintiff to pay the entire stamp duty for the property afresh, overlooking the effect of Section 5 of the Stamp Act. Learned senior counsels appearing for the opposite parties in reply contends, in the event the petitioner has a grievance against the assessment, it is always open to the petitioner to approach the appropriate authorities under the Stamp Act for refund. That apart, it is argued that Section 33 of the Indian Stamp Act does not distinguish as such between the entire subject matter of the agreement in question and any particular portion thereof, but envisages stamp duty to be paid on the entire document sought to be relied on. Learned counsels for the petitioner placed reliance upon a coordinate bench of judgment of this court rendered in 2013, volume 5, CHN, page 6, in support of the provisions that the market value of the subject property cannot be determined arbitrarily without mentioning the methods or basis of such determination and without granting an opportunity of hearing to all the interested parties. Hence, it is further contended by the petitioner, the impugned order is vitiated by contravention of the proposition laid down, Mr. Ghosh has come, laid down in the said report. A perusal of Section 33 of the Act 1918 and 99 Act clearly shows that as rightly contended on behalf of the opposite parties, the provisions does not contemplate segregation of any portion covered by the agreement in respect of which the claim of specific performance or other reliefs has been restricted in the plaint for the purpose of impoundment. The contemplation of the said section encompasses the document sought to be relied on as a whole, and as such the agreement of the petitioner that the petitioner is liable to deposit stamp duty only for the portion of the subject property regarding which relief has been sought in the suit does not hold water. That apart, in the event the petitioner has any grievance against such assessment by the collector, ample recourse is available to the petitioner for seeking refund of the amount under Section 44 and 45 of the 1899 Act itself. Although the petitioner sought to rely on Section 47A of the 1899 Act in support of the propositions that the authorities specified under subsection 3 thereof can only determine the market value after giving parties concerned an opportunity of being heard, does not hold good in the present case, since Section 47(1)(a)(1) contemplates a situation where the registering officer under the Registration Act 1908, while registering any instrument, has reason to believe that the market value of the property has not been duly set forth in the instrument. Such officers shall take appropriate steps within the purview of the said section for assessment of the market value. Such a situation has not arisen in the present case, since the collector assessed the market value on the request of the civil court, and there was no option left before the court itself but to accept such assessment as it is within the
Alright.
contemplation. Now, my lord,
Mr. Ghosh. Mr. Rai, kindly take.
Lord, kindly see. In the earlier occasion, what was the issue? Issue was that the instrument sought to be impounded, Lord, covered a larger area of land, more than 26 kathas or odd. And out of that, only 10 kathas something.
You have a copy of the Stamp Act.
Yes, Lord. Lord, that accordingly, Lord, when the report was filed by the collector.
Mr. Rai, give your book.
Yes.
Junior Mr. Rai, not senior Mr. Rai.
Lord, accordingly.
You are having another book.
Lord, yes. Lord, your lordship kindly see
Yes.
that at the relevant time, Lord, because the collector sent the report, and accordingly, without going through the report, mechanically the civil court directed that you deposit this amount. I found that, Lord, it is a huge amount, and Lord, the portion of the property has already been sold and due stamp duty has been paid in my favor, in my favor sold and it has been paid to the government. Revenue has been paid. Therefore, my lord, we challenge that order before this honorable court that kindly see the instrument covers 26 kathas of land. Already 16 kathas have been sold, 10 kathas is yet to be sold, whatever it may be. Therefore, I am liable to pay stamp duty on 16.
Only with regard to 10 katas.
10 kathas. Lord, that has been turned down by this honorable court. That yes, when the instrument has to be impounded, entire instrument, well, the entire land covered by the instrument, you will have to pay. Lord, that issue has been decided against me that I cannot segregate in view of section 33 as his lordship held. And it was upheld by the honorable apex court. Now, Lord, subsequently we made an application, Right to Information Act, whether the assessment has been made on the basis, on the current rate, on the current date, or on the date of execution of the document. Lord, accordingly, after appeal was preferred, they ultimately gave the reply.
Appeal was preferred.
Appeal against that order, that non-disclosure of the
Oh,
valuation.
under RTI Act.
RTI. Lord, thereafter it was not. In the meantime, they supplied the report. Lord, kindly see the report that related to whether the assessment has been made on the date of execution of the agreement or at the current date.
Mr. Ghosh accepting
Yes.
that the assessment was wrongly made.
Yes.
For the present, let us accept
Yes.
your submission that assessment was wrongly made. What are the recourses available against such wrong assessment?
Lord, wrong assessment recourse.
If it is made,
Yes.
what are the recourses available to an aggrieved party?
Lord, as this honorable court held that when the civil court referred to me, I have no other.
No, I'm not on that. What are the recourses available under the statute? Because we have to go by the statute.
Statute.
So show me what are the recourses available under the statute if there is a wrong assessment made by the collector.
Yes.
With regard to the stamp duty on an instrument.
Lord, whatever it may, Lord, I was not given any scope. I was not handed over the report. Court has also admittedly didn't go through the report.
No, Mr. Ghosh, I accept all your submissions, but show me the recourses available. Because that recourses, I have to relegate you to that recourses because show me the recourses that are available. Once there is an error in an assessment made by an authority under the Stamp Act, what are the recourses available?
By the civil court. Money এমনি করলে তো আর
Lord, ordinarily, Lord, at the time of registration of a document, if it appears from the
Mr. Ghosh, that is registration.
registration,
This is an agreement, need not be registered. Does not require a registered agreement for sale for the purpose of specific performance of contract.
Yes.
So it need not be registered. So it's not a case when a document is placed or is produced before the registration officer for the purpose of registration officer founds that no, there is a deficit in the stamp duty,
yes,
there are recourses available.
recourses provided.
So
Lord.
it's not a case that it requires registration and it was placed before the registration authority. It's a case of impounding by the court sent to the collector, assessment done. According to you, there is an error in assessment.
Yes.
What are the recourses available under the Stamp Act? Because we have to proceed according to that.
Yes.
Show me what are the recourses available under the Stamp Act with regard to that.
Lord, that is not for the assessment while impounding. There is no procedure provided in this act.
Then,
Therefore,
then
therefore,
there is
Lord,
no procedure.
therefore, the civil court will decide if there is error that according to the section it has been done. Civil court will direct the collector to do
Mr.
it.
Ghosh, the civil court, whether, because this is a procedure for assessment, if there is a wrong assessment, there is also a procedure in certain case,
Yes.
but not in this case.
Yes.
And
That is why, my lord, the civil court will have to do. Lord, I pointed out after this order, so far segregation is concerned, I am not entitled to as held by the apex court.
but
So far this question is
if you
concerned.
kindly come to the order of the coordinate bench in the earlier round of litigation. What when senior Mr. Rai was placing, kindly come to page.
Yes.
It starts from page 77.
Yes.
Mr. Ghosh, kindly come to page 80.
Yes.
the
That apart.
that apart.
That apart, in the event the petitioner has any grievance against the assessment by the collector, ample recourse is available to the petitioner for seeking refund.
So
Lord,
here it has been, Mr. Ghosh, it has
Lord,
been
here I
now
can,
your grievance is against assessment for whatever reason. So if your grievance is with regard to assessment, the coordinate bench in the earlier round of litigation
no, Lord,
has said that you have to avail the
Lord,
recourses available under
assessment only question, Lord, whether the entire, I have to pay stamp duty on the entire land
Mr.
or
Gho-
the part. That is the
accepted.
only grievance.
Mr. Ghosh,
But in that
grievance with regard to assessment may be for many reasons.
Yes,
One
I understand.
was with regard to the quantum of the extent or the extent of the land. Other may be with regard to the market value. Here, the coordinate bench held, if you have any grievance against assessment for whatever reasons, court has not specified that. So recourses are available under the Stamp Act. You have to avail those remedies. So once that issue has been decided one way, can a
Lord,
coordinate bench
Lord,
take a different view?
This is not distinguishing feature. Whether it has this particular issue has been decided as a whole.
Issue is with regard to assessment.
Not
Mr.
Lord,
Ghosh,
my
the larger
grievance was-
issue is with regard to assessment.
Lord, my grievance was that assessment in respect to the entire land. That was my grievance. Lord, but here also I can see here in case the entire land, and I can show that the in respect of some portion I have already paid. Then Lord, I have get refund. But so far if the initial stage assessment is made on the wrong calculation, then Lord, I have no remedy.
No, it's
I'm
not
not
that.
entitled to.
No. You are entitled to. Mr. Ghosh,
Then Lord, again it has been assessed according to the rate
Mr. Ghosh,
as
that is
prevailing
there.
at the relevant time.
If you are entitled to refund, the course is because here there is there any provision of appeal in respect of this type of cases? There is no provision of direct appeal.
No.
So only is a case of refund in case of excess payment. So the course which is to be adopted, subject to correction by you, is you have to deposit, because unless you deposit, it cannot be taken into evidence.
That one I know.
If you deposit,
But if
it is taken into evidence, but you say no, excess stamp duty was charged, and there is a provision of refund, you will be entitled to that.
Lord, that I have understood. But here, if I can show before the court, Lord, it is the only the court can decide whether it is right or wrong, because there is no provision in this Stamp Act. Lord, therefore, I approached the court and pointed out that yes, I raised the issue before the Honorable High Court on the question that entire on the basis of entire land.
I follow your argument.
Lord,
According to you,
but-
earlier round of litigation was with regard to the extent.
And
Now you
Lord,
are challenging the market value.
market value, Lord, I'm not challenging. I'm just pointing out.
Defect in the assessment.
Yes, Lord, assessment section 33 says on the date of the execution of the agreement.
Yes.
But here it appears from the report, the answer to the query, they said, no, it has been done at the current rate. Lord, whether this mistake cannot be corrected by the court? Is it bar? Lord, you also know 60 Supreme Court, 64 Supreme Court. There are some relaxation are there. It is not absolute. Principle of res judicata is not absolute govern the matter.
No.
Lord, for court's mistake, court has not looked into the assessment. Lord, I just got it and directed to pay. Client. He has not gone through the report. Not from the order sheet, it will not reflect that court has considered anything. When the report came, he directed the plaintiff to deposit the entire amount. Lord, we pointed out that it is not because of the entire, Lord, that question, Lord, I have already said. Lord, regarding this question, when the duty of the collector is to assess according to section 33 on the date of execution, value of the date of execution, he has not done so. And we are totally in the dark in the matter. But Lord, upon answer to the query, when they say that we have done it at the current rate, current market price. Therefore, I want to point out that it is a mistake. And for that mistake on the part of the court or the authority, Lord, I will
Show me that it was at the current rate.
Huh?
It was assessed at the current rate. Show me that.
Lord, your Lordship can see.
Page.
Yes. That is at page. Yes. Lord, your Lordship can straight away come to page 112. Lord, question number 2.
112.
112, question number to answer. Assessment of market value was done with respect to the date of 30/3/2017.
এই জিনিসটা নেই।
30/3/2017. Lord, that is the and document was executed on 17/10/2004. Document was executed on 17/10/2004. Whereas, Lord, they have said that we have assessed the valuation on the current market, that is 30th March 2017. Lord, settled principle, Lord, for the mistake on the part of the authority of the court, litigant will not suffer. Lord, I have to pay now huge amount, 35 lakhs and odd. If I have no capacity, my suit will go. And it is not mistake apparent. Nobody has to argue, lengthy argument is not necessary. It can be found from the section itself. Did lastly executed or executed.
Yes.
Therefore, Lord, I say that your lordship may direct the court.
What was your application?
Lord, your application under section 100.
Page 113. No, this is the opposition.
Yes.
Your application is at
Yes, Lord, I'm giving.
91.
Yes.
This was the ground.
Lord, yes.
What did the trial court say?
Lord, trial court. Lord, kindly see, in view of the order passed by this honorable court and the apex court, he said that I will not consider. But Lord, my prayer is that to direct reassessment of the matter. I have not said that you also consider that aspect of the matter. I have not said. In 151, I pointed out that this is the mistake. And the court declined to. But two separate things. It is a mistake on the part of the court. Your lordship is settled principle of law that for the mistake on the part of the court, litigant will not suffer. Lord, if it is same issue, then I had nothing to say. Because it has been held up to the apex court, whatever it may be. It may be wrong. It has reached its finality. I could not have questioned it.
Yes, you want to cite any decisions?
Lord, this decision, Lord, 60 Supreme Court, 64 Supreme Court. Your lordship
On res judicata.
res judicata. Lord, your lordship knows that case.
Different stages of the same proceeding. Res judicata will apply.
Two stages. 70, Lord, that is 60 Supreme Court. There is a bar, 60 Supreme Court 941. Satyadhan Ghosal's case. Your lordship knows. Everybody knows, Lord. Thereafter,
Yeah, 60 Supreme Court.
yeah, 1960 Supreme Court, page 941. Yes. Lord, paragraph 7, kindly see.
Paragraph 7.
Yes. The principle of res judicata is based on the need of giving a finality to the judicial decision. What it says is that once a res is judicata, it shall not be adjudged again. Primarily, it applies as between past litigation and future litigation. When a matter, whether on a question of fact or a question of law, has been decided between two parties in one suit or proceeding, and the decision is final, either because no appeal was taken to higher court or because the appeal was dismissed, or no appeal lies. Neither party will be allowed in future suit or proceeding between the same parties to canvass the matter again. This principle of res judicata is embodied in relation to suits in section 11 of the Code of Civil Procedure. But even where section 11 doesn't apply, the principle of res judicata has been applied by courts for the purpose of achieving finality in litigation. The result of this is that the original court as well as the higher court must in any future litigation proceed on the basis that the previous decision was correct. The principle of res judicata applies also in between two stages. In between two stages in the same
Subsequent stages of the same proceeding.
Yes, same proceeding. Earlier, Lord, something is different than something. But there are certain exceptions also that has been given in 64. Lord, extent whether the trial court or a higher court having at an early stage decided a matter in one way will not allow the parties to reagitate the matter again at a subsequent stage of the same proceeding. Does this, however, mean that because at an earlier stage of the litigation a court has decided an interlocutory matter in one way and no appeal has been taken therefrom, or no appeal did lie, a higher court cannot at a later stage of the same litigation consider the said matter again? Lord, thereafter, Lord, here dealing with the question almost a century ago, Privy Council in Maharaja Mahesur Singh versus Bengal government in such and such held that it is open to the appellate court which had not earlier considered the matter to investigate in an appeal from the final decision given grievances of the party in respect of an interlocutory
So
order.
according to you, this issue has not been
This
decided.
issue has not been decided, and Lord 64, Supreme Court is much clarified the matter. In what cases? Lord, there are two things. One is, Lord, in that subsequent development, then the court can pass. Lord, once injunction is refused. But subsequently it appears that the circumstances is so now at the present stage that injunction is required. And that subsequent event may be pointed out before the court and court can again grant the injunction.
Mr. Ghosh, injunction is on a different footing
No, I'm not.
altogether.
Lord,
Change
that is-
circumstances.
There are certain things. And Lord, your Lordship, it was the issue, particular issue, which has already been decided, that cannot be reopened. But if it is not, and in here case, Lord, neither court.
According to you, the issue as to the whether the property is to be valued as on the date of execution of the instrument or
on the
at the
current
current rate, that
This
was
issue
not
was not-
decided in the earlier round of
Earlier
litigation.
question was not
That is
raised.
your submission.
And Lord, neither the court nor the litigants had knowledge about such procedure of assessment, on what basis they have done. But subsequently, on the basis of right of information, they informed that yes, we have done it. And Lord, section 33 is a clear bar that you cannot do it. Then this mistake I have pointed out by an application under section 151. I am not reopening that issue, that I am not liable to pay on the basis of the entire. I am debarred. But so far this question is concerned, where is the difficulty when it's a mistake on the part of and against the law, statute,
No, mistake is on the part of the registration or the this
assessing
revenue,
authority. And
this
Lord,
revenue
court has al-
authorities.
And court has
Mistake
also,
on the part of the revenue authorities.
yeah, revenue authority.
So if there is a mistake on the part of the revenue authorities, Mr. Ghosh, correction
Lord,
or has to be in accordance with the provisions laid down under the statute.
Yes.
Even if you approach the civil court, unless the statute provides whether the civil court, irrespective of the fact that there is no provision in the statute, can direct,
Lord, yes.
satisfy me on this.
Lord, that is Lord, now the entire matter is in the decision of the court. Lord, I have no other alternative. Well, I have to point out that this mistake has been done by the authority. To direct the authority to correct the mistake, civil court has ample power because it is against the section, Lord. It is against section, and this mistake is not telling much upon my client because assessment would be much less.
64 Supreme Court,
Not
which
kind.
page?
খুলে দিল Lord, 64 Supreme Court, page 998, 993.
993. Yes, paragraph.
Lord, paragraph 10, 11. Lord, paragraph 10, I'm saying, the question of fact which arose in two proceedings was identical, would not be in doubt. Of course, they were not in successive suit so as to make the provisions of section 11 of the Civil Procedure Code applicable in terms, that the scope of the principle of res judicata is not confined to what is content in section 11, but is of more general application, is also not in dispute. Again, res judicata could be as much applicable to different stages of the same proceeding as to the finding on issue, conditional finding on issue in different suits. In this connection, we were referred to what this court said in Satyadhan Ghoshal's case, not that's referred to. Such and such, where Dasgupta Jay speaking for the court expressed himself thus. This has been quoted here. Now, we agree, paragraph 11, we agree that generally speaking, these propositions are not open to objection. If the court which rendered the first decision was competent to entertain the suit or other proceeding and had therefore competency to decide the issue or matter, the circumstances that is a tribunal of exclusive jurisdiction or one from whose decision no appeal lay would not be themselves negative the finding on the issue by it being a res judicata in later proceeding. Similarly, as stated already, though section 11 of the Civil Procedure Code clearly contemplates the existence of two suits and the finding in the first being res judicata in the latter suit, it is well established that the principle underlying is equally applicable to the cases of decision rendered at successive stages of the same suit or proceeding. But where the principle of res judicata is involved in the case of a different stages of proceeding in the same suit, the nature of proceeding, the scope of inquiry, this is very important.
The scope of
Inquiry. Scope of inquiry, which the adjective, which the adjectival law provides for the decision being reached, as well as the specific provision made on matters touching the decision, are some of the materials and relevant factor to be considered. Now, this is the important. This is not I want to show you, Lordship, this. This is not paragraph 11.
1000, page 1000. Do you have a
Page-
photocopy of that judgment?
No, I will provide, Lord. There is some trouble in the family, Lord. That's why I could not do it yesterday. Here, Lord, that issue has not been touched at all. And nobody knew that it has happened. No.
Yes.
But therefore, it cannot shield by the provision of the principle of res judicata. And Lord, it is a matter of government revenue. But I am ready to pay, but it should be proper. By mistake, Lord.
Anything
No,
more?
no, I have nothing to say. I have placed everything, Lord. Your Lordship kindly see. This is the two separate things. And your Lordship kindly see whether it is absolute bar. And civil court can. It has ample, Lord, inherent power also to do justice to the parties. For the mistake on the part of the authority to whom it was referred, court didn't find whether it is correct or not, directed to pay, and subsequently it reveals that they have made a mistake. And it is mistake in violation of the statute.
Yes.
Admitted.
Yes, Mr. Rai. You are for opposite party number
14.
14. Yes.
Now, my lord, up to the stage of the Honorable Apex Court, the facts are before your lordship that initial order of impoundment, that was the challenge that is reached up to the Honorable Apex Court. Now, my lord, kindly come to the application now filed under section 151 for my lord, seeking an appropriate order at page 91.
Yes.
Now, my lord, kindly come to page 93. Huh? 1, 20, 23.
93. Yes.
Now, my lord, these application, my lord, filed on 10th January 2023. Although it is not written anywhere, but my lord, in the annexures portion, it is
10th
written
January.
2023.
Yes.
Now, my lord, kindly come to paragraph 8.
Is the date is of any relevance?
Yes. Yes. My lord, since your lordship was asking me the date, my lord, may I clarify that itself. Now, my lord, this order of the Honorable Apex Court that was reviewed. The review application was also dismissed. Now, my lord, kindly see when
What
this,
was the point taken in the review?
that exactly that is not with us. I do not know whether review হয়েছে. No, it is your admission in the application that review was made. Now, my lord, the order of the review is this: application seeking hearing of the review petition in open court is rejected. We have gone through the review petition and the connected papers. We do not find any error, much less apparent in the judgment or order impugned warranting its reconsideration. The review petition is accordingly dismissed. This was dismissed on December 8, 2022. December 8th, 2022.
Yes.
After the order of review, this application was filed.
December.
December 8th, 2022. I'm handing over.
You don't have a copy of the review application
my lord.
because it was not served. Mr. Ghosh, do you have a copy of the review application?
No.
You are also not aware of this order.
No, my lord, he is aware.
I do not know,
He
Lord.
is aware. He
No,
is aware.
Mr.
Maybe-
Ghosh may not be aware. His
Yes,
client
yes,
may be
what-
aware.
No,
totally
Mr.
get-
Ghosh may not be aware, but my lord, his client is aware.
That's why, Lord, I could not. Whatever it may be.
Because my lord, in paragraph 11, my lord, it is specifically stated.
Paragraph
and
11.
Paragraph 11 of at page 94.
Paragraph 11.
At page 94 in
In the application, it has been stated.
Yes. That may I read for you, lordship, that the petitioner challenged such order by filing SLP before the Honorable Apex Court, but without seeking any order and without any reason, the SLP was dismissed by the Honorable Apex Court by order dated such and such, and an application for review thereof also faced the same fate.
Mr. Rai, give me the date of the order dismissing the SLP.
Lord, I have annexed.
Yes,
Copy.
what is the date? Only the
My
date.
lord, that dismissal was made on
August
10th October 2022.
10th
October 2022.
At page 82, my lord. Page 82, my lord, can you see? No, this is nothing. They are not inclined to interfere with the judgment and order passed by the High Court, especially with the
Yes.
So, my lord, after
You have a
the-
copy of the SLP with you?
Well, I can, if your lordship.
Yes. Yes, yes, Mr. Rai.
Yeah, now, my lord, kindly come to my lord. Paragraph 8 at page 93.
Yes.
Have you kindly got it? That at the trial during evidence of the plaintiff witness number 1, when the said agreement dated 17th October 2004 was tendered in view of objection raised by the contesting defendants regarding admissibility of the said document for want of proper stampage thereon. Learned Court directed the document to be remitted to the collector South for assessment of valuation of the property covered by the said document for impounding the same upon payment of proper stamp duty to be paid thereon. Be it noted that due to inadvertence, this Learned Court did not notice that the portion of property covered by the said document was already sold in favor of the petitioner's nominee upon payment of full stamp duty as on the date of execution of the registration of the conveyance. That in view of such mistakes on the part of the Learned Court, the collector assessed the valuation of the entire property covered by
So
the
that
said
was the issue in the earlier round of litigation.
Arkashan. So, my lord, the documents was executed on 17th October 2004. That was before the court. And court on going through the documents directed to pay the
But Mr. Rai, only one thing, what Mr. Ghosh submission is that, and what is also record also reveals that the valuation of the market value has to be on the date of execution.
Yes.
The authorities have said no, it was valued at the current market rate, not as per the. So there is an apparent mistake which was not decided in the earlier round of litigation.
my lord, that was for that the section 8.
Yes.
My lord, the after the order of this honorable court was, my lord, reached its finality, the application was filed for, my lord, under the Right to Information Act. My lord, that kindly come to paragraph 12.
Of the application.
Yes, paragraph 12 of the application.
Yes.
It is stated that up to Honorable Apex Court is SLP, then review petition, everything was dismissed.
Yes, yes, there is
That
no
under
dispute.
legal advice, the petitioner made an application under section 6. That was made on 30th November 2021. That is much before the order of the Apex Court.
Yes. Yes.
Yes. Now, my lord, this application was, my lord, disposed of.
But admittedly, Mr. Rai, this issue was not raised. Issue of market rate. The date on which the market value is to be assessed, that was not raised.
My lord, that was
That is
not,
what Mr.
was
Ghosh is trying
that
to.
was not urged before any
Yes.
any forum.
So Mr. Ghosh is trying to raise this point that since it was not
Well,
urged.
firstly, before this honorable court, Mr. Ghosh can't say that the order passed by the learned trial judge was wrong, since this point was not raised.
That is, no, he says that it will be not be barred by res judicata.
Well, that
Because
will
you
be-
are trying to canvass the point of res judicata.
yes.
Because once this issue has been decided, it cannot be reopened. There, Mr. Ghosh joins issue by saying that this issue as to what is the date on which the market value is to be assessed was not raised in the earlier round of litigation.
Well, that
Not raised, not decided. Not raised, not decided.
so, well, when it is not raised, the documents itself was before the court.
Yes, yes.
So, well, the court, after going through the documents, direct impound of the documents.
But if an issue is not raised,
But that is their fault. That is their fault that this space, knowing
the-
fully well,
will the
knowing fully
principles
well
of-
about the documents, they have not raised.
yes,
So
Let
well,
us-
that has set at rest after the so many orders were passed by this court. After the in every stage, well, they have challenged the order. In all the stages, they have not raised anything. Now, well, at this stage, when the order has reached its finality, now they are wants to revive the points again.
Assessment, revive the assessment,
Assessment.
determination of the stamp
Yes.
value.
Yes. So, after the everything is done, now he is trying. So, my submission, because before your lordship is this, since the order has reached its finality, and they have accepted that. Now, it's an afterthought that they have filed an application for Right to Information Act, and now raising this point. Wants to revive this point so that de novo they can argue everything before the court.
Anything more?
Now, let kindly see the order of this order passed by the landed trial judge.
Yes.
The paragraph 1, 2, 3, 4, 5, fifth paragraph. Further, the plaintiff by filing
Which page you are placing?
the order impugned.
Yes, yes. Order
First
improved,
page.
which page?
First page.
First page, yes.
The line, the paragraph starts with further the plaintiff by filing petition.
Yes.
Dated 10th January 2022. This is important, 10th January 2023. And supplementary affidavit dated 21st January, March 2024 has paid for reassessment of the stamp duty as assessed by the collector with respect to the agreement dated 17th October 2004. At the time of hearing, learned advocate for the plaintiff reiterated the contents of the petition under consideration for 151 of the Code of Civil Procedure dated 10 January 2023. Learned advocate submitted that the concerned collector has wrongly assessed the stamp duty. This is set at rest. This is wrongly assessed the stamp duty with respect to the entire property mentioned in the agreement, though the stamp duty with respect to the landed property measuring 19 katak, 14 chitak has already been paid. Learned advocate also brought to the notice of the court that upon RTI and highlighted that the said RTI was obtained after dismissal of the SLP before the Honorable Apex Court, and further that it manifests from the RTI that the stamp duty was assessed on the basis of the market value prevailing in the year 2017. Learned advocate further submitted that the instant petition has been filed due to such change in circumstances, and more so, it is the settled propositions that the assessment of the stamp duty should be in accordance with the law and should be reasonable. Accordingly, learned advocate prayed for allowing the petition under consideration and for an order of reassessment of the stamp duty. On the other hand, learned advocate for the defendant number 13 raised strong objection and reiterated and contents of the written objection. Learned advocate brought on to the notice of this court upon the order passed by the Honorable Court in CO number such and highlighted that the Honorable Court has already considered the contentions of the plaintiff and has dismissed the prayer of the plaintiff. Learned advocate further submitted that segregation of property in the agreement is not permissible and the entire agreement has to be impounded. Learned advocate for the defendant number 14 also participated in the hearing and emphasized that the prayer of the plaintiff cannot be allowed as the assessment of stamp duty has already been affirmed by the Honorable High Court at Calcutta and the Honorable Apex Court. Both the learned advocates hence urged for rejection of the petition filed by the plaintiff and for proceeding with the suit without any further delay. I have considered the submissions of the learned advocate for the parties. I have also produced the petitions under consideration, written objection along with materials in the record and the documents filed. I have also produced the observation of the Honorable Court in CO number such and such. Now from the record it appears that by the order dated 17th January 2017, this court was pleased to impound the unregistered agreement for sale dated 17th October 2004, and accordingly the same was transmitted to the collector, South 24 Parganas, for proper assessment. Subsequently, by the order dated 22nd January 2019, this court on receipt of the assessment report was pleased to direct the plaintiff to deposit the stamp duty of rupees such and such in the relevant amount code through TR form number 7. The said order was challenged before the Honorable Court, and by the order dated 18th August 2021, in connection with CO number such and such, the Honorable Court was pleased to dismiss the revisional application on contest. The said order of Honorable Court was further challenged before the Honorable Apex Court, but the same was also dismissed, and even the review petition thereto was dismissed. Now, so far as the contention of the learned advocate for the plaintiff regarding assessment of market value with respect to the entire property of the concerned agreement without segregation of the property to such which the stamp duty was already paid is concerned, it appears that the Honorable Court has already considered such submission of the plaintiff in connection with CO number such and such. Further,
But the
so far as
review petition was dismissed. The learned trial judge also took note of that. That
Yes.
The review of the SLP was dismissed.
Yes, yes. So far as the RTI are concerned, be it noted herein that the order of this court dated 22nd January 2019, directing the plaintiff to deposit stamp duty of rupees such and such, has attained its finality, as the Honorable Court has already been pleased to dismiss the revisional application along with SLP and review thereto. Therefore, at this stage, in the light of the order passed by the Honorable Court, this court is of the opinion that the court lacks jurisdiction to review the order passed by this court on 22nd January 2019. As such, this court find no other alternative but to reject the petition filed by the plaintiff. Then, madam, the other portions are there. Then has been pleased to direct this court to dispose of the suit within 6 months. So, madam, the learned judge has considered the submission of the plaintiff there, and learned judge has discussed everything and says that after the order passed by this Honorable Court and its finality to the Honorable Apex Court, now he wants to revive the order that was passed by filing this petition. So that was not permissible before the court.
Do you have
Now,
the copy of the order dated 22nd of January 2019
22nd
Initial
January
order of the trial judge?
of the
Have you
trial
seen-
judge.
Yes. Initial order.
Initial order, yes, yes.
Is it annexed?
না একটা annex করা আছে না? না, আছে মনে হয়। A minute's time for me, Your Lordship.
So, Ghosh, do you have a copy of that order?
I wanted to derive of that.
Yes. The earlier revisional application, it was annexed. Here is there.
It has been annexed.
Earlier revisional application,
You
earlier.
have a copy of
Yes,
that?
yes. Lord kindly.
Yes.
So, my lord, this court, my lord, should not allow my learned friends to, my lord, re-agitate the issue that has already been decided. My lord, whatever avenue he has, my lord, he has the avenue, my lord, under the law.
He has exhausted.
Yes, he has exhausted. Now, my lord, he can't revive this by filing this RTI.
Another round of litigation.
Another round of litigation on the same fact. There will be another round of litigation, and my lord, he wants to, my lord, bypass the order of this court by filing this RTI. That's my sir.
Anything more? Yes, who is for the opposite part number 14? You are. What is your status in the suit? Because why differently you are contesting?
My lord, there are
Mr. Ghosh is the plaintiff.
yes, there are, my lord, several agreements between the parties.
Yes.
That's why, my lord, we were arrayed as defendants, my lord, number 14 in the suit. My lord,
I am telling Lord, what is their position? What happened, Lord? while on the basis of the agreement, the property was being sold part by part, and some part has been sold in favor of me or my nominee. Subsequently, amongst the co-sharers of the vendor of the agreement, that vendor, there is a litigation. There is an order of injunction. Therefore, in view of order of injunction, no transfer was possible. But during the end of that, the my vendors, they have sold to some third parties. Their transfer is from third parties.
So they are the third parties.
Yes.
Opposite party number 14 is the third party.
Opposite parties are not contesting. Real opposite parties, but who are the vendors? They are not contesting.
No, he is the purchaser. Opposite
Purchaser.
party number 14, 13 also.
Yes.
Yes,
Both.
yes,
You are also the subsequent purchaser.
yes.
Yes. Do you have anything more to submit to add Mr. Ray's submission?
I have a little very good submission to make. But in that I will try and on it. Doctor, before that, kindly, your lordship has already perused this order with your lordship. This order essentially deals with that report.
You can use the microphone.
Yes. This order, the previous impugned order that was challenged, order dated 22/1/2019, this essentially deals with the stamp duty of rupees 31,35,111 rupees. That is on the basis of that report, which has also been stated in this order. Thereafter, lordship, the revision was filed on the basis of this amount, that this, whatever it is. Now, my learned friend's contention today is because of so and so A and B reason that this stamp duty I'm not abiding by, I don't want to abide by this stamp duty. And that reason has went up to the Supreme Court. Now he cannot come back again and again say that, no, that reason, okay, Supreme Court has settled. Now this is the reason why I want to challenge this report. The fact remains that that is one amount and that is one report that was challenged, and that amount has been upheld by the Honorable Supreme Court. Now they cannot come back again and resurface the
Anything
proceeding.
more?
Lordship, they have also relied on certain judgments.
Yes. You want to
I
fly?
want to
Die or distinguish?
Distinguish.
Distinguish, yes. Distinguish.
Lordship, I do not have a copy of that judgment. Kindly may it be kept tomorrow. Mr. Bagh,
No tomorrow business. Today itself. You can take the decision. But handle it
may
with
it
care.
be kept as a passover then, because
Handle the book with care, because
Lordship, may I only pray that may today be kept as a passover only to distinguish these judgments, so that my senior
only to
also come and,
distinguish the judgments.
yes.
Ashun. Give me the book. This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order dated August 17, 2024, passed by the learned civil judge, within brackets, Senior Division, 5th Court, Alipur, in title suit number 181 of 2012. Paragraph. By the order impugned, the why two applications? 10th January 2023 and 15th of March 2022.
Well, there are some typographical mistakes. Supplementary affidavit filed by supplementary affidavit, mistakes are directed to be corrected. There is no there is no substantive application. The application are 151 words. There are certain
Page 91 is the substantive application.
Yes. That is 151 application, Lord, kindly prayer to reassess the valuation, not review, nothing else, as contended by my learned friend. Your
It's
Lordship,
basically 10th January 2023 application.
yes,
No, but it is 15th of March 2022.
yes.
Is there any typographical error? Because if it is a corrections, it has to be a subsequent date.
Yes. Dates.
Oh, no. 15th of March is by the defendant number 14. You are 14,
I
defendant
am
number 14.
30. I am 40.
It is his application, Mr. Ray's application, praying for a direction to deposit the stamp duty.
Yes.
So this, it's not that your application.
No, my application was not supplementary. That was for correction.
Alright, কি বললাম? By the said by the order impugned, the application of the petitioner dated 10th of January 2023 and the application filed by the defendant number 14 / opposite party number 13, Mr. Ray.
13. Opposite party number
13.
14.
14.
You are
14. I am for 13.
13.
You said you are for 14.
And I am Susrutai Foundation.
14. Opposite party 14, Lord,
14.
defendant
Yes.
number
Opposite party number 14, defendant number 14.
Yes.
আচ্ছা কি বললাম ডিফারেন্ট নাম্বার dated 15th of March 2022 were disposed of. The petition dated 15th of March 20 no, in the petition dated 15th of March 2022, the opposite party number 14 prayed for a direction upon the petitioner herein to deposit the stamp duty assessed by the collector and for proceeding with the suit in accordance with law. The petitioner filed the application dated 10th of January 2023 under section 151 of the Code of Civil Procedure, praying for a direction upon the authority to reassess the stamp duty which was to reassess the stamp duty of the instrument which of the agreement to reassess the stamp duty on the instrument being agreement dated 17th of October 2004, which was impounded by the learned trial judge. Paragraph. Petitioner filed a suit for specific performance of contract and for other consequential reliefs. Paragraph. During the evidence of the PW1, the agreement dated 17th of October 2004 was tendered, and in view of the objection raised by the defendants, by the contesting defendants, with regard to the admissibility of the said instrument for want of proper stamp duty, the agreement dated 17th of October 2004 was impounded and the same was sent to the collector for assessment of the proper stamp duty. Pursuant thereto, the collector assessed the stamp duty and a report dated 7th of September 2018 was forwarded to the learned trial judge. Mr. From the said report, it appears that from the said report, as per the said report, the valuation of the property, which was the subject matter of the said instrument, was assessed at rupees 5,39,70,865 as per the government rules, and a stamp duty of rupees 31,35,111 was directed to be paid by the purchaser of the agreement for sale as per the order passed by the collector, 24 Pogonas South. After perusing the report dated 7th of September 2018, the learned trial judge, by an order dated 22nd of January 2019, directed the plaintiff/petitioner herein to deposit the stamp duty assessed by the collector, which was specifically indicated in the said report. Being aggrieved by the order dated 22nd of January 2019, petitioner approached this court by filing CO 2047 of 2019, which was dismissed by the coordinate bench by order dated 11th of August 2021. The petitioner herein approached the Honorable Supreme Court by filing a special leave to appeal within bracket C numbers
17328 of 2022.
being for special leave to appeal within bracket C numbers 17328 of 2022, which was dismissed by the Honorable Supreme Court by the order dated 10th of October 2022. Full stop. It is not in dispute that a revision application was filed to review the order dated 10th of October 2022, and the same was dismissed by order dated 8th of December 2022. Full stop. Thereafter, the petitioner filed the instant application under section 151 of the Code of Civil Procedure, praying for reassessment of the stamp duty payable by the petitioner. Full stop. Such application was dismissed by the learned trial judge, which is under challenge in this application, in this civil revision application paragraph. Mr. Ghosh, learned senior advocate, appearing for the petitioner, submits that in the earlier round of litigation, the petitioner approached the learned trial judge with a prayer for reassessment on the ground that, not reassessment, earlier round.
We are challenging that the order has been passed by the assessing the entire
All right,
property.
কি বললো? Approach the learned trial judge
Directly,
Correct.
my lord.
Mr. Ghosh, Lal, senior advocate appealing for the petitioner, submits that the order dated 22nd of January 2019, passed by the learned trial judge, was challenged in the earlier round of litigation on the ground that the valuation of the entire property,
Covered by the agreement.
which was the subject matter of the agreement, was taken into consideration, whereas the petitioner, whereas the subject matter of the dispute involved in the suit relates only to a portion thereof. Gustav, he submits that that the coordinate bench in the earlier round of litigation only had the occasion to decide such aspect of the matter and nothing else. So, he further submits that pursuant to an information furnished under the provisions of the Right to Information Act 2005. Here is 2005.
2005.
Right to Information Act, 2005. The petitioner came to know that the stamp duty was assessed on the basis of the market value of the property as on the current date, in spite when the statute prescribes that such market value has to be ascertained as on the date of execution of the instrument, which is the agreement dated October 17, 2004. Mr. Ghosh submits that the learned trial judge, instead of appreciating the issue raised by the petitioner in the application under section 151 of the Code of Civil Procedure, mechanically dismiss the same by on the ground that such issue has already attained finality in view of the fact that in the earlier round of litigation, the matter reached up to the Honorable Supreme Court. First up, in support of his submission that the decisions rendered in the earlier round of litigation cannot be said to be res judicata, Mr. Ghosh placed reliance upon the decisions of the Honorable Supreme Court in the case of such and such versus such and such, reported at AIR 1960 Supreme Court 941, and such versus such and such, reported at AIR 1964 within bracket SC 993. Yes, Mr. Ghosh, that is all your submission. Yes, paragraph. Next, Mr. Rayal Honor, senior advocate appearing for the opposite party number 14, took this court to the orders passed by this court in the orders passed by the coordinate bench in the earlier round of litigation, as well as the orders passed by the Honorable Supreme Court in the special leave to appeal and the review petition. First up, he submits that since the issue with regard to the assessment made by the assessment made by the collector as to the stamp duty payable on the agreement dated October 17, 2004 has already reached its finality, the same cannot be reopened at the subsequent stages of the same proceeding. He submits that he reiterates the well-settled proposition of law that the principles of res judicata shall apply even at the subsequent stages of the same proceeding. Paragraph, Mr. Rai, anything more?
No, my lord. And my lord, this RTI information was sought for before, although before the uh, the Supreme
Before
Court
the review application.
review application, and my lord, this was available to him on 1st January, 1st November 2022,
After Supreme Court case.
Page
page 90,
1st November 2022.
1st November 2022.
Yes.
And my lord, the review was my lord, dismissed on 8th December 2020.
He further submits that the information furnished under the,
Lord, applied in 21.
yes.
That
No,
is,
Mr. Rai says that it was available to you on 1st of November 2022. That is before the dismissal of the review.
but as that was not issue, that I could not.
That is his submission. I am recording that.
yes.
You know? Under the 2005 Act was available to the petitioner when the was available at the was available with the petitioner prior to the dismissal of the review application. Just a paragraph. The learned advocate appearing, Mr. Bagh, learned advocate appearing for the opposite party number 13, assisted by, what is your name?
Devdatta Shaha.
Assisted by Mr. Shah, submits that the assessment made by the collector, which was appearing in the report dated 7th of September 2008, was
18.
accepted by the learned
2008.
trial judge, and such order was affirmed up to the Honorable Supreme Court, and therefore, the same cannot be reopened at the instance of the petitioner in the guard of an application under section 151 of the Code of Civil Procedure. First up, heard the learned advocates for the respective parties, and
Lordship, one more thing, that in the situation they want to have any grievance against the assessment, they can also always fall back to the Stamp Act to seek a refund. Only that.
बोलना? Materials placed. Sir. It is not in dispute that upon the agreement for sale dated 17th October 2004 being impounded by the learned trial judge, the collector assessed the valuation of the property involved in the said agreement, and the stamp duty which was required to be paid by the purchaser of the agreement for sale was also indicated in the said report. Stop. The report of the collector was accepted by the learned trial judge by order dated 22nd of January 2019. Stop. The petitioner challenged the petitioner approached this Honorable Court by filing CO 2047 of 2019, alleging challenging the order of the learned trial judge accepting the assessment made by the collector. Paragraph. Though Mr. Ghosh may be, though it appears from the order dated August 11, 2021, passed in CO number 2047 of 2019, that the petitioner raised grievances though it ap- that though na- though it appears from the order that one of the grievance of the petitioner was that the valuation was made on the entire property, which was the subject matter of the agreement, but the fact remains that the assessment made by the collector in respect of the property, which was the subject matter of the agreement for sale, was challenged before the coordinate bench in CO number 2047 of 2019. To stop, paragraph. In the earlier round of litigation, the petitioner, while challenging the assessment made by the collector, thought it fit to raise only the grievances, his grievance as to the extent of the property which was the subject matter of the agreement, but the fact remains that it was incumbent upon a party challenging an assessment to raise all grounds of defense or attack in the state proceeding. To stop, even though the petitioner may not have specifically raised the issue as to the determination of the market value as on the date of execution of the instrument, but the same ought to have been raised as a ground of defense against the assessment made by the collector. To stop, the coordinate bench in the order dated 11th of October 2021 specifically observed that in the event the petitioner has any grievance against the assessment by the collector, ample recourse is available to the petitioner for seeking refund of the amount under section 44 and 45 of the 1899 Act itself. To stop, the coordinate bench, after noting the provisions of section 47 capital A of the 1899 Act, observed that section 47A within bracket 1 contemplates a situation where the registering officer under the Registration Act, 1908, while registering any instrument within bracket, including an agreement bracket close, has reason to believe that the market value of the property has not been duly set forth in the instrument, such officer shall take appropriate steps within the purview of the said section for assessment of the market value. After noting the said provision, the learned trial judge observed that such a situation has not arisen in the case on hand, since the collector assessed the market value on the request of the civil judge, and there was no option left before the court itself but to accept such assessment as it is within the contemplation of section 35 and 33 and 35 of the 1899 Act. Therefore, the coordinate bench expressed a finding, returned a finding that the assessment of the market value made by the collector could not be interfered with by the court. First up, the petitioner has tried to challenge the assessment made by the collector on by raising a different ground. First up, as observed by this court herein before, that the petitioner ought to have raised such a ground in defense or in attack against the challenge to the assessment made by the collector in the earlier round of litigation. First up, Mr. Rai Lanet, senior advocate appearing for the opposite party number 14, was right in submitting that the information supplied by the concerned authority under the 2005 Act was within the knowledge of the petitioner prior to the disposal of the review application by the Honorable Supreme Court. First up, the learned trial judge, in the considered view of the court, was right in holding that the petitioner is attempting to review an order passed by it which has not been interfered with up to the Honorable Supreme Court. And therefore, it was not open to the learned trial judge to reopen such issue. First up, this court do not find any infirmity in the findings recorded by the learned trial judge while dismissing the application under disposing of the application under section 151 of the code filed by the petitioner herein on 10th of January 2023. First up, at the cost of at this stage, it would be relevant to point out that the coordinate bench in the order dated 11th of August 2021 has also noted that there is ample recourse available to the petitioner for seeking refund of the amount under section 44 and 45 of the 1899. In view thereof, this court is not inclined to interfere with the order impugned. Accordingly, the revision application stands dismissed without, however, any order as to costs. The learned trial judge is requested to dispose of the title suit in the light of the directions passed by a coordinate bench on an earlier occasion.
The amount has not yet been deposited.
If they do not deposit the amount, law will take its own course, Mr. Rai.
We have filed one.
The court cannot compel him to deposit.
Lord, one thing, Lord. Your Lordship, kindly record my submission. Yes, subsequently we came to learn that has not been recorded. And
Subsequent,
we came to learn that this has not been done according to section 33, which provides the date of assessment, date of the execution of the agreement. And Lord,
I have recorded your submission.
Lord, that
But Mr. Ghosh, I have recorded your submission that it was market value as on the date of execution of the instrument,
No, no, I
not
have-
on the current market value.
I came to learn it but after passing of the order that
After,
I made an application in 2021
yes,
for no. to
after
no.
the order of the coordinate bench.
Yes.
Yes.
Here, lots of
Ashun.
record it,
Uh,
and also, Lord, kindly distinguish about 64 Supreme Court. Why, how it is not applicable? Your
Sorry,
Lordship
sorry.
has
The
not
judgment
discussed that aspect
boi
of the
boi
matter.
Yes.
Yes.
No book is here, so I left.
Here,
it.
Lord,
Where is the 60th Supreme Court?
60
That is the parent judgment.
এই যে,
That's it.
60th Supreme Court, what is the page?
941. That has been clarified in 64.
একটা জায়গা লিখুন তো Mr. Ghosh Lanet, senior advocate, would contend that the petitioner came to learn of the fact that the assessment was made by the collector on the basis of the current market value only after the order was passed by the coordinate bench in the earlier round of litigation.
Even after the disposal of SLP, after disposal of SLP,
After disposal of the কি বললাম?
SLP,
After disposal of the special leave petition by the Honorable Supreme
the application was made in 21.
Correct. After disposal, coordinate bench, as per disposal of the special leave petition by the Honorable Supreme Court. What's up? The said the said no.
Yeah, and he had no, had,
The petitioner
had no
came to
scope.
learn of the error in the assessment on the ground that the market value as on the date of execution of the agreement was not taken into consideration cannot be a ground to reopen the assessment which was ultimately accepted up to the Honorable Supreme Court. First up, paragraph. There is no quarrel to the proposition of law laid down by the Honorable Supreme Court in Satyadhan Ghoshal Supra that the principle of res judicata applies. That the principle of res judicata is based on the need of giving a finality to judicial decisions, and the principle of res judicata applies also as between two stages in the same litigation to the extent that a court, whether the trial court or a higher court, having at an earlier stage decided a matter in one way, will not allow the parties to re-agitate the matter again at a subsequent stage of the same proceeding. First up, in the case on hand, the petitioner assailed the assessment made by the collector in the earlier round of litigation. Such challenge was unsuccessful up to the Honorable Supreme Court, and therefore the assessment made by the collector in respect of the property which was the subject matter of the agreement attained finality. In view thereof, this court is of the considered view that the decision of the Honorable Supreme Court in the case of Satyadhan Ghoshal cannot come to the aid of the petitioner in the case on hand, but the same supports the case of the opposite parties. What is the page in the 64th Supreme Court? 993.
Mark 993. Mark.
Yes. Paragraph 11 you referred to.
Paragraph 11.
Lord, last part condition. After quotation of Satyodhan Gosal, Lord, thereafter, next page.
That was considered Satyodhan Gosal.
Yeah.
Always.
Bidding judgment is
Always. Constructive review.
In Arjun Singh Supra, the Honorable Supreme Court reiterated the well-settled proposition of law that the principles of Section 11 of the Code of Civil Procedure is equally applicable to the cases of decisions rendered at subsequent stages of the same suit or proceeding. ঠিক আছে এটা উপরে দিয়ে দেবেন পরের 60টা করে দেবেন
Lord, there it has been clarified that last part, that in where it can be challenged.
issues
That-
issues Mr. Ghosh I have dealt with while deciding
Lord, I have
on
seen.
the issue of res
Lord,
judicata.
your only thing, Lord, it is, Lord, I am my submission. Why I have pointed out my short submission. Section 36 says on the date of last execution. That has not been gone into in the order. That is the spirit of the order, that if it appears that statute says something, and as it appears, apparently that collector has done something.
Mr. Ghosh, I appreciate that.
Because, Lord, that
But
is,
since in the earlier round of litigation,
I know, Lord,
assessment
Lord, your lordship, your
taken
lordship-
one ground,
No,
that
Lord,
is
I
the-
want to, because of this should be gone. Otherwise, Lord, I have, in case,
you can
has
avail
not-
the recourses available under the Stamp Act.
Lord, that I know. But, Lord, I am saying, Lord, your lordship's judgment, your lordship kindly record my submission that I pointed out that section 33 provides the last date of execution, but it has not
I have
been done.
recorded that submission. That submission I have recorded. That it ought to have been made, and you have come to know of that fact after the dismissal of the special
And
litigation. I have
therefore,
recorded that.
I wanted to distinguish this, that it can be done. That is my submission.
Yes,
Congrats.
thank you, Mr.
That's
Mr. Ghosh, Mr. Ghosh, kindly take this, your earlier revision application. Yes, call the passover matter.
Oh, appearance.
Well, I'm sorry, I was not present.
Yes, call the passover matters.
Item number 2.
Yes, my lord, I am appearing for the petitioner. My lord,
Yes,
on the last occasion, I was submitting before your lordship, a partition suit was filed by the
this
plaintiff.
is for the first time or it was served?
No, first time. It was never heard, my lord,
Never heard.
never heard. It was released, my lord, because, my lord, I mentioned for upgradation.
Yes, what is this matter?
My matter is that, my lord, partition suit was filed by the plaintiff. I am the defendant in the suit. The suit was dismissed. Appeal was filed by the plaintiff. My lord, hearing was concluded. Thereafter, my lord, without any application, my lord, they filed.
Hearing of the appeal was concluded.
Yes, they filed certain documents for their possession, to show their possession over the defendant's land, RS Khotian. I objected to that. That was allowed. Now the
Where is the application dated 11th of
My
March
lord, my lord.
2024?
Edu Joseph Kadam.
Why have you not annexed this
My lord,
application?
that time I don't get, my lord. At the time of filing, hurriedly it was filed, my lord. Thrice cost was imposed upon my client by the learned trial court for not getting any order from this court. Order to 41 ka waive kar- কবে ফাইল করবে স্যার? এটা যেটা করবে
CPC টা দিন। Where is your objection?
Yes, I have annexed.
You have annexed. Where is
Yes,
that?
yes. Just a minute.
Page
My lord, page 59.
59.
Yes. There, my lord, in 7, it has been stated that appellanter পক্ষ respondent পক্ষ থেকে appeal hearing শেষ হয়ে আছে। এই অবস্থায় after completion of trial and also completion of appeal hearing, respondent পক্ষ থেকে যে
What
benefit.
happened? The appeal of judgment has been passed.
No, now, no, that has not been passed.
What is the next date in the appeal?
21st. Now there is
21st
of this month.
of
Now-
this month.
Yes, now there is something more, my lord. 41-27, thereafter again filed. To
Again file.
Again filed. Kindly see after passing of the order. To curtail the latter, I have indicated in my petition. Something, my lord, unexpected.
Order 41, Rule 27 for that.
For that thereafter, passing of the impugned order, not before.
By the order impugned,
My lord,
the appellant / opposite party herein was given liberty to file the copy of the arrest Khotians by the date fixed. Paragraph. The learned advocate appearing for the petitioner submits that after conclusion of hearing in the title appeal number 14 of 2010, the learned court of the learned first appellate court allowed the appellant to file the copy of the arrest record of rights. Full stop. The question would be as to whether a party, the question would be as to whether the appellant could be allowed to produce additional evidence before the appellate court without satisfying the provisions laid down under Order 41, Rule 27 of the Code of Civil Procedure. Stop. On a query of the court, the learned advocate appearing for the petitioner submits that the said appeal is still pending and the next date has been fixed on 21st
21st, as I gathered,
of what?
February.
21st of February 2025. Stop. Petitioner is directed to serve a copy of this application by registered post with acknowledgement due by speed post, by registered speed post with acknowledgement due upon the opposite parties and file an affidavit of service on the upon the opposite parties hearing. Full stop. In addition, the petitioner will be at liberty to serve a copy of this application upon the learned advocate representing the opposite parties before the learned first appellate court.
My lord,
Full stop. There shall be an order of stay of all further proceedings in title appeal number
14 of 2000.
14 of 2010 pending before the
learned additional sessions judge, first track, third court, Bosirhat.
pending before the learned additional district judge, first track, court number 3, Bosirhat, till the end of March 2025 or until further orders, whichever is earlier. List this matter. Parties are at where?
My lord, parties are at, just a minute. My lord, that is Haroa, not 24 Parganas.
27th of February.
27th of February.
List this matter on 27th of February under the heading
Right.
assigned matters. Next.
Deeply obliged.
The application টা রেখে দেবেন। Yes, call the other matter.
My lord, I am appearing for the petitioner. My lord, this is extension of interim order. My lord, I have
Extension of interim order.
this was appearing under the heading earlier before the other court extension of interim order. My lord, the affidavit of service is here. Earlier, Justice Basu has been pleased to.
Who is appearing for the other side?
My lord, I have served the learned advocate of the trial court as well as the.
No one has appeared
No
in
one
this.
has appeared till date, my lord. This is with regard to the amendment where, my lord, after admission, my lord, the schedule has been changed. After admission, that is in plain, my lord, the schedule has been mentioned.
At what stage of the proceeding? Trial commenced, not commenced.
No.
Trial has not
No, no,
commenced.
no.
So a liberal approach is to be taken if the trial has not commenced.
My lord, trial কি এটা হয়েছিল? My lord, liberal approach, my lord, my lord, entire, my lord, scheduled land has been changed. That means, if your lordship kindly sees, my lord.
Scheduled land has been changed.
Yes.
What is the suit for? What
My
is the
lord,
suit for?
suit for declaration and recovery of khas possession. In respect
Declaration
of,
and recovery of khas possession.
yes, in respect of co-scheduled property,
In
out
respect
of-
of. In
My lord,
respect of.
in respect of co-scheduled property.
Or kho.
Co and co, grateful. Now, in co, if your lordship kindly comes to, I'm page 19. That is the schedule of the plaint.
Yes.
Trial শুরু হয়নি তো? My lord, kindly see, my lord. 63 দাগে ক শিডিউল
Yes.
5 ডেসিমেলের মধ্যে দক্ষিণাংশে 3 ডেসিমেল। Your lordship got, my lord, the last line. Page 19.
Yes.
That is the declaration. And eviction in respect of kho schedule, that is in the next page. Page 20. 63 দাগের মধ্যে বাস্তু 5 ডেসিমেলের মধ্যে দক্ষিণাংশে 3 ডেসিমেলের মধ্যে হাত নকশায় স্ট্রিপ চিহ্নিত ভূমি যার দৈর্ঘ্য 26 ফুট প্রস্থ 3 ফুট মোট 78 ফুট বি
Yes.
স্ট্রিপ।
Now how it has been sought to be changed by way of amendment?
Yes, I am grateful. কত নম্বর? আরে অবজেকশন কি শিডিউলটা বলো না এখানে অ্যাসিস্ট করতে এসেছি এটা কোন হ্যাঁ 50 এই জানো না ভাই তোমাকে আর ভিডিও কোন অ্যামেন্ডমেন্ট 44. Your lordship kindly comes to page 44, that is the proposed amendment.
Yes.
Now kindly see 2, 1 and 2, column 2, last তফসিল সংশোধন page my lord 44.
Page 44, yes.
Yes, proposed amendment. RG তফসিল.
So show me that the scheduled property has been
Yes,
sought to be changed.
that schedule I am placing, my lord.
Yes.
RG তফসিল সম্পত্তির বিবরণী খ শিডিউল সম্পত্তির বিবরণ সাফ কলমে কাটা যাইবে এবং ক তফসিল সম্পত্তির বিবরণে 63 দাগে বাস্তু, your lordship kindly appreciate 5 ডেসিমেল কথার পর দক্ষিণাংশের 3 ডেসিমেল কথাগুলি সাফ কলমে কাটা যাইবে। That means from 3 it becomes 5. Two decimal was added. So nature and character is changed. So far this suit is concerned, which has been considered by Justice Basu at the time of my lord passing an order of stay. And the next one, the next page, page 45.
Stay is subsisting, or it has been vacated.
No, my lord, stay is vacated, but during pendency of the state, we have filed the extension application and we have served. It was not heard by the other court. My lord, during
It was
pendency,
served upon whom?
my lord, the learned advocate of the trial court as well as the my lord defendant. Only the pro forma defendant did not receive. All of them received, my lord. I have filed the affidavit of service. Your lordship, kindly grant stay for some time and fix any date convenient to your lordship.
Can 1 of 2024. This is an application for extension of interim order. It has been submitted by the learned advocate for the petitioner that the said application has been served upon the opposite parties as well as upon the learned advocate representing the opposite parties before the learned trial judge. First up, it appears from the record that a coordinate bench by an order dated 20th of September 2024 passed an interim order of stay of all further proceedings of title suit number 161 of 2018 pending before the learned civil judge senior division second court Tomluk till the end of December 2024 or until further orders, whichever is earlier. The petitioner filed the application for extension of the interim order on December 6, 2024. And the same is still pending. First up, in view thereof, there shall be an order of stay of all further proceedings in the proceedings in title suit number 161 of 2018 pending before the learned civil judge senior division second court Tomluk in title suit number title suit number pending before till the end of March 2025 or until further orders, whichever is earlier. Yes, the petitioner is directed to communicate this order to the opposite parties as well as upon the learned advocate representing the opposite parties in the court below, before the learned trial judge and file an affidavit of service on the next day. আচ্ছা আগেরটা তো কিন্তু affidavit of service এর কথাটা লিখে দেবেন ঠিক আছে first up list this matter on 27th of February under the heading assigned matters. Next, আচ্ছা affidavit of service filed in court today is taken on record করে দেবেন. Yes, call the list.
Deeply obliged.
I my lord that M victim matter বন্ধ করে দিই
Yes,
my lord your lordship last occasion
Direction
direct me
submit a
to
report.
add the cyber crime department
yes,
of
yes. What happened? I directed a report to be filed.
Lordship,
What
yeah.
happened? What is your report? Steps taken?
Lordship, Lordship's order has been complied and the LS
my lord my instruction 20 minutes ago but that from my client that my lord all the videos against my
Have you
client
gone through this report?
but that report no my lord.
Serve a copy.
Para 4, Lordship, kindly see.
দেখছি পূর্বস্থলী পিএস ভুল লিখেছে, মঙ্গলকোট পিএস। মঙ্গলকোট পিএস তো
পুলিশ কেসটা মঙ্গল করতে।
Yes, Mr. Chatterjee, according to them, steps have been taken. You go through the report.
Yes, my lord.
Pursuant to the earlier order dated 5th of February 2025, a report has been filed by the inspector in charge. This is a communication, Mr. Ahmed, to the learned advocate. This is not a report.
But today I have received the report only a
This is the
few minutes
letter.
ago.
Letter. এটা আপনাকে লেটার করেছে।
The report.
report number
Report not in the
communication
form of evidence.
made by the inspector in charge, Cybercrime Police Station, Purbo Bardhaman District Police, dated 12th of February 2025, to the learned government leader, has been placed before this court, which is taken on record. To start, a copy of such communication has been supplied to Mr. Chatterjee, learned advocate for the petitioner, in course of this, in course of hearing of this application. First up, it has been stated in paragraph 4 of the said report that steps have been taken, and it has been reported that the all the contents have been removed from the YouTube channels. First up, on the prayer of Mr. Chatterjee, learned advocate for the petitioner, hearing of the matter stands adjourned for this week.
Your lordship's availability, next day your lordship available.
Next week it will appear.
Next week.
Yes, next. Next week next
একটা ইয়ে করে দিন।
another same heading. Yes.
এই দুটো আছে।
Next.
হ্যাঁ, রিমুভ হয়েছে, দুটো চ্যানেল রিমুভ হয়নি, দুটো মাত্র। বলবো কি my lord, may I submit one thing, my lord? My lord, so far my lord, instruction 20 minutes ago, all channels against my client removed, but 2 channel of that accused Maharaj is still consist, my lord.
But it's not against you.
Not against you, but
If
that
it
is
is not against you, how are you affected?
My lord, that is provoke, my lord, that is provoke the other, my lord, girl child, the other.
That is
My
a
lord,
different thing altogether.
That is going on, my lord. And one thing that I have already.
That is
my
not
lord,
the subject matter. It was against you. It was directed. It has been done.
and one thing that they, my lord, published that the Maharaj is in Bangladesh, my lord, for some time, but not in the correctional home. That is, my lord.
Yes, call the next matter.
Lordship next week for what, Lordship? Next
For
week
order.
For hearing of the
For
matter.
hearing of the main matter.
Yes.
Get for your lord.
Call the next matter.
Appear for the petitioner. The substitution application.
Yes, Mr. Ghosh, you are appearing.
I am with him, Lord.
Yes. Yes, what is this matter?
This came up for substitution application. Lordship, there's one.
This is what? Substitution application.
It's
Within time.
out of time. Out of time.
Out of
abatement. Abatement also. Setting as
Abatement. Setting aside abatement. Have you seen the recent decision of the Honorable Supreme Court passed yesterday or day before yesterday? On Order 22, Rule 10, capital A, Order 22, Rule 2, Rule 4. You have gone through the judgment. Not gone through the judgment. Yes. What is the delay? How much delay?
195.
195 days. You are opposing.
Actually, my lord,
Yes. Where is the application?
Can 1032, Lordship.
What is the main matter?
Main matter, Lordship, removing of garbage. Removing of garbage by the corporation also.
Removal of garbage from where?
From my land.
My land, vacant land was, the neighbors they thrown my lord garbage. Accordingly accumulated. Thereafter, a notice was issued.
This was a Vastu land
First to land.
or water body.
First to land. First to. But what happened, my lord? Thereafter, I approached the corporation. Corporation local councillor directed us to deposit the money. They will remove. Accordingly, money was deposited. Thereafter, my lord, they came that they said they remove it up to the street. That was also done. Some portion has been
We
removed.
will remove it up to,
The main road.
so garbage will be dumped on the road.
From the place,
From your land,
from your land to the road, it will be replaced and they will they remove it from road itself by their.
no, I could not follow. You have to remove from
They
your
say
own land.
that, they say that from my land I will have to replace to the road, carry to
So
the
you
road,
have to put it on the road.
and
take
they
from
will
the road.
carry. A portion of that was done. Thereafter, the portion which was removed, they took away. Thereafter, no steps were taken and nothing has been.
Yes, Mr. Ghosh.
I find that this is not a challenge here. He must challenge the notice. That notice must speaks of that commission of nuisance because of certain things have there, the breeding of mosquito. That notice was issued for removal. At page 65.
Page 65 of the writ petition.
And that is the notice. That notice does not speak about that removal of the garbage. But so far as the private property, if the garbage is accumulated, it is not my duty to remove the garbage from the private property.
So, upon inspection, you found that this water is being accumulated on some.
Bucket and broken pots are there where the water continuing to remain. Therefore, that could be the breeding place of the mosquitoes. Therefore, we have asked him to remove that. This is nothing to do with the garbage and other things.
How the petitioner, where he will remove? Mr. Ghosh says that he has also deposited the charges.
But charges so far as that I do not find. Where is the document for getting the payment?
Page 61.
61.
With representation repeated that I have deposited.
And
You
then
remove
say, it has been once removed.
No, not removed. Not fully.
Because Mr. Ghosh,
No, section 333.
Mr. Ghosh, only one thing. Even if, assuming that the petitioner is directed to remove, where they will keep?
So instead of the roadside, because corporation's duty to remove the garbage from the roadside, number one. Number two, each area, there is a garbage vat type is there, where the garbage is to be accumulated. And from there, they will definitely collect it. But it cannot be said that it is to be removed from the private property itself. Because
But if somebody neighbors have, I have not kept the garbage. I have not kept
no,
the garbage.
you may not keep it. You may not keep it because you have to protect your own property. By either way, certain judicial proceedings or against someone who are putting the garbage. But I cannot, because this will be in a bad instance, and every person will say that I have the money, you collect garbage from my residential premises.
But according to you, is there any garbage vat near the
But I have
property?
to ascertain nearby, but definitely it should be, or my lord, that the every
Mr. Ghosh,
time
what
nowadays.
is the extent of the garbage?
Lord,
Can you not put it in that vat?
Lord, your lordship, kindly once, Lord, paragraph 11 of the writ petition, page 9. Read it. Kindly, Lord.
Paragraph 11.
Yes.
So according to you, some portion of the garbage you have kept
To
it
this-
on the road, but they did not come.
They did not come, carried to the road, they didn't
Instead
come.
of going to
Thereafter,
that-
under the public,
So, Mr. Ghosh, if a specific date is fixed, because he will accumulate, if you, that is the allegation, your men did not come. If you take instructions, give a specific date when your man will collect from the roadside. He will keep it on the roadside,
I-
1 or 2 days
Malad,
prior to that.
But I'll take one of the present situation, number one. Number two, if the garbage is accumulated anywhere in a particular private property, then Malad, when it will be, because nowadays the person, Malad, every time Malad, they visit the each ward and each places naturally. They Malad have to take instructions that how they are monitoring the regarding removal of the garbage from that particular place. Then I will come back to you, Lordship, my lord.
Yes, only one thing, with regard to this, if a specific date you can inspect, make an inspection, what is the extent, because if assuming the quantity of the garbage is so much, if it is kept on the road, then also it will be a difficult thing
yes,
for the users to use the road. So you make an inspection. If it can be done, a date may be fixed. If Mr. Ghosh can arrange for putting, Mr. Gopal Ghosh can arrange for
Yes.
putting it on the roadside, on that specific date, he will take it from there.
But the provision is 333, they will remove from the premises, each premises.
No,
And I will have to pay
Show me
solid
that
waste,
provision.
I will have to pay solid waste charge for that reason.
Kolkata Corporation Act টা দিন তো।
Lord, 333, kindly see.
তাই তো। 333,
Yes. Rubbish, offensive matters, etc. আর চার্জেসটা কোথায়?
এই যে আছে আছে কমিশনার চার্জ পরে আছে।
ট্যাক্সটা কত নেই? 300 কত? না, ট্যাক্সটা যেটা
it may be done. So once it could be done. Then each occasion, it will be accumulated. Each occasion, he has to pay that amount.
This is not my garbage. It has
No,
been
no,
thrown
it
to
may
my
be
property by the
but it is your
neighbors.
land. It is your land. Every occasion, then you have to pay the amount.
Mr. Ghosh, you have to protect your property.
Yes.
You have to protect your property.
Each
So
occasion,
let
you
us,
have
for
to
the
pay.
time being, I will direct them to make an inspection, to make an assessment, and to submit a report on the next.
My lord,
Mr. Ghosh, also you take instructions
my lord.
upon inspection, if you fix a date, so that Mr. Ghosh, if it is possible, otherwise, if it is not possible to be kept on the road, if Mr. Ghosh clients pays charges, you can remove it. Otherwise, if it is stacked on the road, it may be a difficult thing also.
But I'll ascertain that, and my lord, this so far as the removal part is
The-
concerned, sometimes, my lord,
Yes,
each
who are
occasion
you?
he has to pay the amount.
Who are you?
Private this one.
Lord, they are throwing. Lord, they are neighbors. The
They-
side of that space, they are residing.
They are-
Everything is thrown.
My lord, normality, what it is done, if a land is,
Natural
You
human
have to-
conduct.
you have to protect your property.
my lord, what is done, you should know, my lord, when the vacant land is there, whoever, even, my lord, beside my premises,
Natural human conduct.
No, even-
Vacant is there, everybody will.
no, even maybe.
Mr. Ghosh, if it is your property, you have to protect your property.
They are
My lord, I find even beside my house, my lord, the
That's the
vacant land is there, it is, everybody is throwing.
my landed Ghosh clients trying to encroach my property and
That is
throw the
another.
garbage.
Encroachment is a different thing. Yes, what is the application for substitution? Which
No, that is not
application?
can.
What?
1032
আমার property
আসুন।
encroach করছে।
Oh.
হ্যাঁ,
1032 of 2020, ওটা বোধহয় নতুন একটা নাম্বার আছে দেখে নেবে না?
construction
This is an application
আমার
for
property ঢুকে।
substitution
হ্যাঁ?
of the
আমরা
sole petitioner
চলছে।
after
No, no, respond to my own.
of the respondent number 4.
Yes.
Oh, sorry.
Private.
Of the
Report হলো আমার premises। Report হলো
in the cost title, it has not been stated. Of the respondent number 4, after setting aside abatement on condonation of delay. So stop. After going through the said application, after going through the averments made in the said application, and after hearing the learned advocates for the respective parties, this court finds that the delay has been, the delay in filing the application for substitution after setting aside abatement has been sufficiently explained. In view thereof, the delay in filing the application for substitution after condonation of delay is condoned. Full stop. The petitioner has
me,
হুম,
বেশি দীপক ময় মিত্র,
আমরা-
ময় মিত্র,
হ্যাঁ।
তাদের কন্টিনিউয়াস জোন আছে, ও বলছে আমি ডিগ্রি পেয়েছি যে
given satisfactory explanation for not filing the application for substitution within the prescribed period of limitation. Full stop. It has been stated in the
কতদিন করে এতদিনের পরে আসছে
application that the respondent number 4 died intestate on February 13, 2019, leaving behind him surviving his wife, 2 sons, and a daughter whose particulars have been specifically stated in paragraph 1 of the said application. First up, in view, after hearing the learned advocates for the respective parties, this court is of the view that the right to proceed against the heirs of the deceased private respondent survives in this writ petition, and therefore the heirs of the deceased respondent as specifically stated in paragraph 1 of the said application be substituted in place and stead of the deceased private respondent number 4 after setting aside abatement. So, sir, the department is directed to carry out the necessary amendments in the cost title of the writ petition within a week from date. First up, paragraph. The writ petition is taken up for hearing. First up, Mr. Ghosh, learned advocate, appearing for the Mr. Ghosh, learned senior advocate. পুরো নামটাই লিখুন, দুজনেই মিস্টার ঘোষ আছে। Mr. Gopal Chandra Ghosh, learned senior advocate, appearing for the petitioner, submits that the Kolkata Municipal Corporation have not taken any steps to remove the garbage from the property of the petitioner in spite of the fact that a substantial amount has been charged by the Kolkata Municipal Corporation from the petitioner. Full stop. After hearing the learned advocates for the respective parties, this court feels that a direction should be passed upon the Kolkata Municipal Corporation to inspect the property in question, being premises number
Premises number, Lord, just.
Premises number, my premises number 64.
premises number 158,
150.
Altu Purvapalli, Kolkata 78, and to submit a report as to whether there is garbage dumped in the said property. Full stop. Mr. Ghosh, who shall file the report? Who shall file the report?
The executive engineer of the
Which respondent?
SW, let me see, my lord, whether they have made a party or not.
Executive health officer? No.
No, executive, no, health officer. Executive engineer of the SWM department, solid waste manager, he has not a party here.
333, Mr. Ghosh, is the municipal commissioner.
Municipal commissioners delegate the power of different departments are there and they are set
Who is
up.
the delegated officer?
The executive engineer, SWM department of the concerned borough.
Put it in a piece of paper, একটা কাগজ দিন তো। On the prayer of Mr. Gopal Chandra Ghosh, learned advocate for the petitioner, leave is granted to the petitioner to add ওই executive engineer যেটা বলবেন পুরোটা as a party respondent in this writ petition, comma, here and now. Since Mr. Alok Ghosh, learned advocate, usually appears for the Kolkata Municipal Corporation and can represent the added respondent, there is no necessity to serve a copy of the fresh application upon the, to serve a copy of the writ petition upon Mr. Ghosh. First up, the petitioner shall be obliged to serve a copy of the amended cause title of the writ petition upon the learned advocates for the respondents on or before উনিশ তারিখ করে দিন, on or before February 19, 2025. The executive engineer the added respondent herein shall is directed to file a report as directed herein before. Yes, when Mr. Ghosh? No, Mr. Golok Ghosh.
My lord,
When?
after 3 weeks here, 2 weeks or 3 weeks, my lord.
2 weeks. On or before February 26, 2025. First up, an advance copy of the said report shall be served upon the learned advocate for the petitioner and the private respondent. List this matter
12.
on February 27,
word
2025.
Matter will have 25.
27, February 27, 2025. Mr. Ghosh, ask your advocate on record to add the added respondent. Mr. Alok Ghosh is supplying the particulars.
Yes.
Executive engineer SPW is supplying. Hearing. Can disposed of. Any other can is there? No.
No.
Anything more, Mr. Ghosh?
Executive engineer, SW department. M.
No.
SW department means solid waste department.
Management, solid waste management department.
Solid waste management department. SWM department.
হ্যাঁ,
Solid waste management
গোপালনাথ
department.
ডিপার্টমেন্টে জমা হবে।
ঠিক আছে, লিখে
গোপালনাথ
দিন ওটা।
ডিপার্টমেন্টে জমা দিয়ে দেবো।
আর করে দিন ওটা পুরো।
As record number 6.
এখানে হবে না।
Mr. Ghosh, that is Boro number at ward number at
Yes.
107 ward.
Word number 12,
What number 107? So,
word number 107.
Yes, call the next matter.
9.
SWM is solid waste management.
And I'm for the petitioner. This is my restoration
Yes.
application. That is can 2, my lord.
I am for the state.
That was filed within time.
What is the application?
Application can 2 is my application for restoration.
Dismiss for default.
This is for default. It was
Is at
discussed
the
20th.
motion stage,
No, my lord, at hearing stage.
hearing stage.
Affidavit has been exchanged.
Yes, what is the main matter?
Main matter is that
We are newly appointed lordship. We received the applications and petitions, but I have not received the reply which he
that
has
was
appointed
solved earlier upon the my lord.
lordship.
Learned advocate who was representing the state at that point of time.
All right, what is this matter?
But initially,
What have you paid for?
petitioners as well as some other persons were appointed as an organizing teacher in a madrasa. Subsequently, 2011, the madrasa was recognized, but the service of the petitioners has not been approved. So they preferred a writ petition. That writ petition was disposed of with a direction upon the DI to consider their case. DI considered and rejected. Thereafter, again another
What is the ground of rejection?
that there
It
was
was found that when the district
the
level
rule-
inspection team went there,
district
he
level
found you were not working.
but district level inspection team, there was no inspection made at that time. It was rejected on the ground.
What is the ground of
Under the
rejection?
Madrasa Service Commission, there was no provision for the approval. Subsequently, 2 other writ petitioners moved a writ petition separately. That writ petition was allowed. Against that writ petitioner, state writ petition ordered by the state travel to the
Yes,
Supreme
Mr.
Court.
Pari, you are appearing.
I sought for instruction from the DME. I have not received any instruction from the Director of Madrasa Education.
You have not received instructions.
No, madam. I sought for instruction, madam.
So not today,
Not today, not this week, madam.
not this week.
My restoration application may be allowed today. It is filed within time, my lord.
Restoration main matter, once for all it will be.
Lordship.
No piecemeal business.
Reply to some-
Ashwin. An accommodation has been paid for by the learned advocate for the respondents. Full stop. In view thereof, list this matter in the next.
In the perhaps read petition, in the read application, someone else was there. Malat, I don't have any copy of the opposition and reply. In the application, my lord, they have served the copy. The office of the common pleader served the copy to us only, my lord.
For that, I will serve one copy of the opposition and reply.
You
That is-
serve a copy of the
I will
opposition
serve
and the reply.
Opposition and reply, I will serve.
Opposition has been filed in court.
Opposition
Uh,
filed.
my lord, you can
Opposition-
say, my lord.
Opposition perhaps has been filed.
The body,
My order of
opposition has to be filed. Check it from the records.
He has affirmed the reply, my lord.
I have my reply, my lord. Opposition,
opposition has not been filed. No.
Check up whether the opposition has been filed, otherwise you have to file the opposition. Yes, call the next matter. Huh? Next week থাকবে. Yes, next.
5 June.
Lordship is allowing the restoration application or only simply not this week? Not this.
Everything. Same heading, same heading. No piecemeal business. Restoration, again keeping it for 5 years, no.
No, no. The file ta khali 1 second ekটু খালি check করুন।
Yes, next, next.
7 and 12.
But in 11 and 12, my lord, I will request your lordship to take up 12 first. Admitted amount on account of work executed. Where is the admission? Show me the admission.
Lord, that was my opening argument.
Yes,
but, Lord,
yes.
that is
So you have to start from there.
no, Lord.
Don't proceed from a different angle altogether. That is why I recorded that for that purpose.
It's a hearing matter. The can has lost his life.
What is the can?
Can is that I cannot issue a warrant.
Can is to get the main matter hard.
Okay.
That is
That
the
is
purpose.
No, that was not that time, Milord. That was Milord, not for the expeditious hearing of the main matter.
Mr.
But
Mukherjee,
it has
you have
lost
filed
its
this
scope.
can. 1 of 2023.
Milord, in
That's his can. 1 of 20.
We are conscious that we are.
Mr. Ghosh is not so acquainted, Milord. Then
Mr. Mukherjee, you are reminding the court to pass appropriate orders.
I have no admission.
No, Mr. Mukherjee, you are reminding the court to pass appropriate orders. Yes, yes, that is your application.
That's already an inappropriate order there.
That is your application. You are reminding the court that the court has
your
to pass
lordship gives me
appropriate.
Milord 10 minutes of your lordship's time first. So that Milord I can place. Milord, it's a matter, Milord, where your lordship has to give me at least 10 minutes time. So that I can Milord place the gamut of the case before
Any
your lordship.
admitted amount is there, Mr. Mukherjee?
Milord, it's very difficult, Milord, to answer Milord in such a way because there are 2 writ petition. Milord, may I say what is Milord the scope of the writ petition as on today?
So disputed question of fact.
Milord, if that be so, your lordship will not. I know, Milord, your lordship will not give any relief to me. I know that. So that's why, Milord, may I place, Milord, what can be the scope of these 2 writ petition as on this day? Milord, if your lordship takes up the second writ petition once.
Second writ petition.
Milord, the second item, Milord, the item number 12. That was my first writ petition.
How it could go down?
It should not have. Milord, if your lordship takes up, Milord, there in my first writ petition, what was there, Milord? There was a Milord, tender where Milord, I was the successful bidder. Milord, the work order was being issued for coal mining. There, Milord, during
Mr. Mukherjee, give a brief outline of
yes,
the...
that's that is I am giving.
Yes.
Milord, during that, my allegation was that they have not given us the actual patch area for the purpose of Milord, the excavating the coal. There are certain Milord
Coal India.
hindrance.
Coal
Yes.
India.
Yes. There are certain hindrance, Milord. They were not in a position. Eastern Coal. They were not, it is a position, admitted position, I shall show before your lordship. They express by their own minutes that they are not in a position to give Milord to hand over the actual area for excavation. And also, Milord, there were a high tension line installed over there, which also, Milord, create hindrance for the purpose of execution of the work in question. But in the meantime, they have issued, Milord, they have issued a banning order. Milord, it's a, I will not say, Milord, it's a cancellation. They have given a conditional order. You start doing work, otherwise I shall cancel. Milord, that is, Milord, the cancel of banning order of Milord 11th of March 2021. And Milord, the notice dated 30th August 2021. 11th March page number. Milord, if your lordship takes up, Milord, my petition.
What happened after that? You have challenged that banning order.
Banning order as well as, Milord, that notice for cancellation, conditional cancellation.
This writ petition.
In this writ petition. There, Milord, I got an order of interim protection.
if your lordship takes up that order once, that your lordship will get from the order
What
sheet.
is the nature of the interim order?
Not to give effect of both these notice.
What happened after that?
They have come up with an application for modification
Of that order?
Yes. There are tender clause, my lord, clause 9 suggests regarding suspension, cancellation, my lord, banning. That is the provision of 9. There is a clause of 10 which they can invoke without cancellation of all these things. They can proceed to do the rest of the work by appointment of new contractor.
Mukherjee, your effective prayer is to quash that banning order.
No, I am coming. Today, when they have opted for a modification to be filed on the basis of clause 10 of the tender notification, then clause 10 suggests, yes, without cancelling of these things, they can proceed with the rest of the work since it's a public project by appointment of new contractor. For that reason, whatever work I have done in the meantime, that measurement has to be done. And thereafter, they can proceed with for tendering of the rest of the work, which they have opted by filing a modification application while I was enjoying an interim order in the first writ petition. So in my respectful submission, that modification application came up and liberty was granted to them. They can proceed with the rest of the work without cancellation, apropos to their suggestion of applying the provision of clause 10 of the tender notification. So once that goes, in my respectful submission, my prayer with regard to cancellation of banning order and their conditional cancellation notification, that too goes. Because they have opted for clause 10 of the tender notification. I shall show before your lordship what is clause 9 and what is clause 10. So once...
Show me clause 10.
Yes, I shall. Lord, if your lordship takes up page 96 of my lord's brief. Has your lordship got it, Milord?
Yes.
Clause 10, carrying out part work at risk and cost of the contractor. Has your lordship got it?
Yes.
If the progress of the work or any portion of the work is unsatisfactory, the engineer in charge, after giving the contractor 15 days notice in writing, without cancelling, kindly marks this portion, or terminating the contract, shall be entitled to employ another agency for executing the job to carry out the work departmentally or contractually through tendering tendering process, either wholly or partly, enabling the contractor with cost involved, engineering another agency or with the engaging another agency or with the cost of labor and the price of materials, as the case may be. The certificate to be issued by the engineer in charge for the cost of the work so done shall be final and conclusive, and the extra cost, if any, shall be borne by the contractor. However, when this clause is invoked, any other penalty will not be applicable other than on account of shortfall of quantities as per clause 6.2. Now, my lord, next, the value of the work taken away shall be calculated for items and quantities taken away at the agreement rate, including price variation, as applicable on the day when notice in writing for taking away part work was issued to the contractor. The contractor from whom part work is being taken out shall not be allowed to participate in the tendering process, if any. So, my lord, I shall show before your lordship the clause 9, the cancellation clause. There are also a suspension can be made. That suspension can be for 3 years. But in the clause 10, what they can do without cancellation, without banning, they can proceed with for doing the extra work by engaging new contractor. And in that event, what is my restriction? I should not be take part in the tender process for the rest of the work to be done by the coal field. So here they have opted for this clause 10. So if your lordship now takes up the modification order once. এখানে আছে Lord, modification order is your lordship's order sheet. Your lordship will get order dated 3rd of March 2022.
Give me a minute.
Done.
Show me the banning notice.
Banning notice, my lord, in the first writ petition here. Yeah, banning notice.
Yes, first writ petition which you are
Yes,
placing.
268. Hmm. 268. Hmm. This is 11th March 2021. $269, my lord, the subject to the portion.
This is a show cause notice.
Yes. But, my lord, if your lordship turns over the page to page 269, the quote, unquote portion, your lordship, therefore, in the interest of ECL, there is no option but to ban you and partner of your joint venture from participating future tendering of ECL for a period of
This is
1
not
year.
the show cause notice. This is the consideration of your reply to the show cause notice.
So, to that effect, they have banned me for 1 year for participation. That they can do, I shall show before your lordship, applying the provision of tender clause 9 of the tender notification. I shall show before your lordship. Now, this is, my lord, the one of the, my lord, challenge in the my first writ petition. Second challenge is at page.
So you wanted to show the modification application.
Prior to that, if your lordship said this, since I have shown this also, your lordship kindly see page 313. The second challenge.
313.
313.
What does he want? What he's facing?
Lord, either. Lord, Lord, he should not follow. Lord, I am addressing to the court. So, Lord, if the court can follow me, Lord, he has to understood that.
I have to follow what you are asking for.
শুনুন না দাদা, শুনলে বুঝতে পারবেন।
Yes, yes.
Lord, page 30th August.
Mr. Mukherjee, don't turn to your right or left.
Yes,
Look
Lord,
at the
that's
front.
very difficult. Yes. 30th August 2021, Lord,
Two senior
memorandum.
lawyers on your right.
Yes, yes.
One simple. That's it.
30th August 2021, my lord, this is also challenged. The last two line, if your lordship kindly see. Lord, I am harping on this. So, considering the gravity of the situation and your failure to operate the mine, we have no other option except termination of your work order if the mine working not gets restarted shortly. So, that's why I say it's a conditional. So, they have not terminated me. At that juncture, I approach this honorable court. This honorable court state both this notification.
What is the relief which you are now claiming?
I shall come. Lord, in the first writ petition, according to me, may I place the modification order?
Mr. Mukherjee, first writ petition, second writ petition, it boils down to one thing.
No.
What is the...
No, that's why I have not placed before your lordship what is my claim in the second writ petition. That's
right. What is the ultimate relief which you are claiming? Not first, not second, ultimate relief.
Lord, according to me, when the modification application is being moved by them, they have opted clause 10, the cancellation, the banning order, and the notice which I have shown before your lordship, page 313.
That they have given a go by
according to me. Now, if that be so, if your lordship takes up my prayer once,
so you will be entitled to
at least
complete that work, accepting the portion which was...
No, not at all, because rest of the work has been done by engaging new contractor. So I am not on that. My performance security to the tune of 2 crore 81 lakh, they cannot withhold. They cannot, because they have given a go by.
So you want
I'm coming.
Refund of that.
I'm coming, Milord. So, Milord, performance security is an amount which they cannot retain. The retention money, 1 crore 1,66,600, they cannot retain. These two head. Now I will come to the portion wherein, Lord, I have held for, Lord, withheld money which have been there. They have withheld for the purpose of unpaid bills. There your lordship will just ask me a question, where is the admission? Lord, I shall come to that. So, my lord, if your lordship is at par with me, that after the clause 10 is being invoked by their modification application, my challenge with respect to cancellation of banning order and conditional cancel order itself goes by their own conduct, and they cannot withhold my performance security as well as retention money. Now, with regard to the withheld money with RA bill, but if your lordship takes up my, may I just show before your lordship, prayer H is the comprehensive sum, Lord, I have prayed for at page 55 in this petition. In this writ petition. Prayer H at page 55. Lord, 3 heads I have divided. your lordship will get the 4 crore amount. This is unpaid bill, which can be disputed.
It's crore or lakh, Mr. Mukherjee. You can count better.
1 crore 15 lakh 59,262.
You can count better.
My lord, I cannot. My lord, both of my learned senior friends, my lord, can. I cannot.
Yes.
Let me not open my mouth about here, my lord, and
Yes.
After the retention money,
count.
my lord, in my respectful
What
submission,
is the first sum?
first sum is, my lord, the withheld money with regard to RA bills, which can be said to be disputed. I am, my lord, being an officer of the court, submitting before your lordship. I shall show how far it can be said to be, my lord, admitted. That is the subject matter, my lord, which your lordship will decide. But with regard to the retention money and, my lord, performance security, which has been stated by this honorable court today, after that option being opted by them, they don't have any option but to release these two ahead, at least, as on this day, in my respectful submission. Now, my lord, what is the submission with regard to my averment in unpaid bill? Your lordship takes up, my lord, page 30 of my writ petition, paragraph 40.
So your prayer is limited only to this.
Now, in this writ petition, because in my
So what is the other writ petition?
I shall come, my lord. In the other writ petition, what happened? They tried to float tender without, my lord, ascertaining what the work I have done. Because clause 10, I have shown before your lordship, that is their duty prior to floating new tender for doing the rest of the work. They have to first quantify what was the work that I was done pursuant to the previous work order. So that was not being done. So this honorable court again, my lord, state that thereafter, my lord, direction was passed again by their approach that yes, you first quantify what are the work that was done. That was being done, my lord, according to me, that was not done properly. So, my lord, there are, my lord, claim and counterclaim to that effect. That is the scope of the second writ petition. Though in the second writ petition, I prayed that the latter tendering is bad. Latter tender order, work order floated, that is bad. But subsequently, since, my lord, this honorable court directed the measurement to be done, the work has been, my lord, completed, floated, my lord, new contractor engaged.
So that claim goes.
That claim goes. That has become infructuous by passage of time. That's Mr. Ghosh, my lord, was addressing, my lord, at the first juncture. What is my prayer? My lord, my prayer now again boils down to this prayer H of my first writ petition. Because according to me, my lord, in my respectful submission, that
Mr. Mukherjee, that is also related to some extent to the measurement aspect.
to some extent.
So unless
I shall come.
that measurement
that
aspect
RA bill,
is decided,
that RA bills.
so this
I bow down before your lordship. But
not only RA bills, this performance security was, and with regard
but I
to
shall
this,
show before your lordship the performance security and retention they cannot touch if they cannot invoke clause 9. They have not even invoked clause 9. I have shown before your lordship that was a conditional, my lord, direction passed by them, issued by them, stated by this honorable court in the interagnum period when they have seen that this has been stated. I shall show. Thereafter, they have come up with a proposal that they will opt instead of 9, 10. So in 10, there are certain other measures which they can take. There, they cannot withhold my performance security because
there's only one thing. Everything, your entire claim,
mine,
is with regard to a contract. According to you, you have performed a part of that contract.
According to both of us.
Yes. Performed a part of that contract. So according to you, you are entitled to release of these amounts as well as certain amounts on account of running bills.
Running bills.
So all this is subject to the measurement.
No,
and also you are disputing.
No, my lord, subject to measurement. My lord, in my respect to submission, my lord, but I have, my lord, in respect to performance security and retention amount, it is not subject to anything. My RA bills, my lord, I bow down.
Yes. So let us assume, let us leave those two aside with regard to RA bills and the measurement aspect, which is the subject matter of the second writ petition. So all these are disputed questions of fact. They have made a measurement by their competent officers in your presence. Maybe
no, in my respectful submission, that measurement was not being done at all. They have planned it and thereafter just
again, that is a disputed question of fact.
Yes.
According to them, inspection, measurement was done upon due notice. According to you, either no notice was served or nothing was done.
Notice, my lord. That was the direction of this honorable court.
So either way, so it is a disputed question of fact. So on this boils down your claim of RA bills. Now, it's a composite contract. Your claim arises out of a contract. A portion is a disputed question of
A
fact.
portion, maybe, but
A
not the
portion,
rest
I
portion.
said. A portion is a disputed question of fact. If that is so, whether piecemeal, apart, writ court, another civil court, or any other forum according to that should be done, or the entire thing can be relegated to a forum which can adjudicate all these issues in one go.
I shall satisfy before your lordship. If this is your lordship's query, my lord, that whether at least the admitted position while deciding a writ petition, whether the writ court can, my lord. হ্যাঁ, ঠিক আছে তো জজ সাহেবের জাজমেন্ট ছাড়াও আমি দেখব
দেখেছিস তো
কি what
Other judge the division fell from your lordship right now.
he will distinguish that.
I just wanted to know whether he knew about it. I'm sure he knows. If not, then he may.
Why are you underestimating him?
Lord, I have to be in Calcutta High Court for some time. Can never do that.
Yes.
So, my lord, paragraph 40 of my writ petition, which I wanted to invite your lordship.
Which writ petition?
My lord, first writ petition. I am placing, my lord, entirely
Paragraph 40.
paragraph 40, my lord, 40 at page 30 of the my lord's brief.
No, only Mr. Mukherjee, I was wondering only with regard to this, whether for the purpose of deciding that, if I have to enter into the facts with regard to the other thing, there is some finding against any of the parties, it may affect either of them.
So what I proposing before your lordship, my
That
lord,
is
subject
for you to take a decision.
no, subject to correction, my lord, if
Because
if
either
with
way,
regard to,
it appears prima facie appears to be all interrelated issues.
my lord, if today, my lord, if this, my lord,
Because whether you are entitled to, if you are entitled to or not, for this,
my lord,
all
the bank
this,
guarantee they cannot invoke because the bank guarantee, my lord, I am protected by the
how long it
initial-
will take?
my lord, this completion of this argument,
Yes, yes.
my lord, I will take some time because
How much I am asking you?
my lord, regarding the factual part, I can complete today.
Factual, legal,
But my lord, my lord, the proposition of law which, my lord, my lord, I have to assist before your lordship, my lord, regarding that portion, that whether in a piecemeal admitted position can your lordship release, because what, my lord, what I was suggesting that today, if this admitted amount can be released by them, this আমি বলছি না তোমাকে রাজি হচ্ছে with if, my lord, this portion of 4 crore 15 lakh RAP, that we can sit down together. That we can sit down together.
If both of you can sit down and resolve the
Regarding that,
issues, nothing-
RAP, because other two part, my learned senior friend can argue that they have right to, my lord, withhold this in spite of invoking clause 10.
which two parts?
My lord, the retention and the bank guarantee. If that be so, they can argue on this, and other amount, your lordship did not be venture
Yes,
on
Mr.
that. We
Ghosh,
can sit
any admitted amount is there.
No admission, my lord. He is going admission. There's a contract.
Can both of you sit together
But
with
if-
regard to these admissions?
My lord, he wants an admission. Now, my lord, I ask, where is the admission? There is a contract. There are clauses in the contract. Now, my lord, if a contract has not been acted upon, my lord, there is a breach. My lord, what the breach results in, my lord? A damage. What is the damage? It's an unliquidated sum. So, for liquidation, one has to go to a forum for adjudication. Now, my lord, he is asking for refund of, my lord, the return of the bank guarantee. Now, lordship knows in catena of cases, bank guarantee, unconditional, my lord, courts are not going to ask the return of the bank guarantee or, my lord, injunctive bank guarantee. Good, bad, indifferently, my lord, this was
Except
injunctive.
in certain exceptional cases.
Fraud, special equity, irretrievable injury. None of the case made out in the writ petition. Now, my lord, he wants the bank guarantee back in a writ petition. My lord, it's an independent contract of the main contract.
And he's admittedly.
And it's a federal bank's case, my lord. And admittedly, he has left the work. That's his writ petition. If he has left the work
So, Chatterjee, which judgment you are carrying?
in the division bench, my lord, Mr.
What is the cost title?
My lord, it's cost title Eastern versus UCC RLA. Refund of money not permissible. And
All right, yes,
subsequently,
Mr. Mukherjee, how much time it will take?
Lord, I just, my lord, come back, my lord, with this, my lord, to answer this judgment. To answer this judgment. And my lord, my learned senior friend is saying, my lord, this is not an exceptional case because they can withhold, my lord, applying.
How much time you will
Guarantee
take?
is an independent contract. Federal Bank's
How much
case,
time?
my lord. And even in Standard Chartered Bank, my lord,
Next
refund
week,
not
my lord,
allowed.
any day, your lordship.
How much time I am asking you?
How much time, my lord?
I am in,
Take
my lord,
half an hour.
my lord, I am in writ petition number 2. Mr. Chatterjee is in number 1.
Okay.
1 and 2. You are in petition number 1.
I am in 2. I am always after it. And he is in
Lord,
1.
I am always oppressed.
Mr. Mukherjee, learned advocate, but the petitioner commences his argument, but could not conclude due to paucity of time. List this matter in the next week under the same heading.
In all fairness, my lord, should take recourse to the, my lord, dispute resolution mechanism in the contract.
Arbitration.
There, my lord, there is a dispute.
Suit, not arbitration.
Suit, commercial code Asansol.
Arbitration, parties both may agree to forego that.
I'll, my lord, better go to commercial court and do it, my lord.
Ah.
Less expensive, less, my lord, and my lord,
Where,
it is, my
where?
lord. They have already got a decree. They have already got decrees in
Court.
CCL.
One before the court or the arbitrator?
Other matter. Yes, you have got a
But that's a
decree.
different company.
That is
different
Mr. Ghosh's personal knowledge.
different company.
They file the
different-
affidavits.
Item number 1 for
Affidavit
judgment.
in opposition.
Affidavit in opposition in the matters in question. One is an
Mr.
affidavit.
Mukherjee, your reply.
There is a supplementary affidavit.
Mr. Chatterjee, your opposition. Tale likhe din. Affidavits in opposition and the replies there too. One reply or composite reply?
Reply, my lord.
এই নেই ব্যাগে খুঁজে পাচ্ছে না তাহলে শুধু অপোজিশনটা লিখে দিন এফিডেভিটস ইন অপোজিশন filed in court today are taken on
The
record.
supplementary affidavit once, my lord, I have used, my lord, served them copy.
You are filing what? Supplementary affidavit.
My lord, the affidavit in reply, my lord, is also.
340.
Supplementary affidavit you have dealt with.
No. The opposition.
No, that,
Yes,
that
we have dealt
in
with.
the opposition you have dealt with.
Question of
The supplementary affidavit filed by the petitioner and the affidavit in one reply or two replies.
One reply in
Item number 12.
item number 12.
One reply. Item number 12. Affidavit in reply in item number 12 এ যে WPA নাম্বারটা লিখে দেবেন. Is taken on record.
Any date? কবে রাত্রি আছে?
অপোজিশনটা থাকবে.
শুধু সোমবার দিনটা বাদ। সোমবার দিন হচ্ছে না,
Which
না,
date,
next week
Lordship?
হতে পারে না, next week ঠিক আছে, ঠিক আছে।
Next week, list this matter, another same meeting in the next week.
Which date? কোনো date নেই?
Item number 1
Mukherjee
for
said
judgment.
next week. Next will appear in the next
When
week.
lordship sits.
Whenever my lords. That is
Anybody is there. Thursday definitely দাদা। Thursday আমি তোমায় বলে দেবো।
Yes.
You
Item
should
number,
always, my lord, take the recourse. It's a disputed money claim. It's better, my lord, he goes there and gets, my lord, whatever he fights out.
Mr. Mukherjee wants to take his chance in the read court.
Take, after lordship's order, following that is a subsequent order, my lord, by the division bench. This has been followed subsequently by the Honorable Chief Justice, my lord. In a matter, my lord, even blacklisting, he has said, please go there.
For the reasons as aforesaid, the writ petition stands allowed. The order dated 18th of March 2020 stands set aside and quashed. The authorities of Coal India Limited are directed to grant notional promotion to the petitioners in the revised E5 and E6, revised E6 grade with retrospective effect from 5th of February 2007 and 20th of September 2013 respectively, and to refix the seniority of the petitioners and the other executives in the revised E5 grade and revised E6 grade on the basis of the effective date of first class MMC. It is however made clear that in case of tie, subclause 2 II and III of clause A of the recommendation for removing the existing anomaly as extracted hereinbefore shall be followed. The entire exercise shall be completed by the authorities of CIL as expeditiously as possible, but positively within a period of 4 weeks from the date of receipt of a server copy of this order.
My lord rises. Oh, my lord.
Let me put my signature, Mr. Kormakar.
Yeah, I am waiting. My lord, what you wanted, my lord, that's why I was waiting.
My lord, I'm praying for stay of the operation of the order.
Ashun. After this order was pronounced, the learned advocate appearing for the respondents prayed for stay of operation of this order. So, sir, you are admitting
No, my lord, because next DPC is likely to happen in.
such prayer is opposed by the learned advocate appearing for the petitioner. The prayer for stay is considered and rejected by this court. হ্যাঁ ওই লেটারটা পাঠিয়ে দিন হ্যাঁ add করে দিন।
My lord, considered and rejected.
Yes,
Deeply appreciated. My lord, I couldn't hear.
what have you heard?
I heard considered and I could not hear further.
It's good not to hear the later portion of that. Yes, Mr. Kolkata.
Your Lordship was pleased, Lord, to allow a mentioning for hearing of a matter. Lord, the file has come. The problem is.
When did I allow?
Lord, it was allowed last week. It was allowed last week, Lord. The file is here from your Lordship's court. Lord, the difficulty is there are two applications. Out of that, one application is untraceable. We have a copy of that application. Is by virtue of that, it may be listed, Lord.
It will be listed, but in due course, Mr. Kormokar.
I do not have any problem.
Because
Lord, whenever
some
it's
mentioning
convenient for my lord, my lord.
since you have mentioned, why are you handing over the slip again?
Because of the non-availability of that can, Lord, the matter is not being listed. That's the problem.
ওটা দেখে নিন তো বলছে ক্যান না থাকার জন্য বোধহয় লিস্টে করা আছে।
Great.
was appearing, where is চলে গেছে দেখে নিন আগে অর্ডার গুলোতে আছে কিনা দেখে নিন
My lord, item,
পাঠিয়ে দেবেন ওই হ্যাঁ
my lord, item number 13. I'm praying to fix on Monday, my lord, because my.
Item number 13.
Yes, my lord. There was a direction for filing of supplementary affidavit. I
Then don't file today. I'm making it not 13 and not this week করে দিন।
Great. May I file this?
Not today. Next file on the next day.
Great.
No. Wherever the can is there, it will be indicated. দেখো নি
Unfortunately, my lord, it's
ক্যানটা
not.
কোথায় আছে ওখানে
Even if it is untraceable, I have a photocopy, my lord, I can.
ফটোকপি দিয়ে দেবে তখন তাহলে করে দেবেন ক্যান নট ফাউন্ড বলে লিস্টে দিয়ে দেবেন তারপর
Grateful.